Respond.
Wait, please, your lordship. Sir, I have filed a writ petition on this matter regarding to transfer my lord.
Just a minute. What does it? Around 40,
और ज्यादातर WBC 345 और WBC 3 and WBC 440 21
Writ petitions are allowed. Reports are returned back if you need. Reports ready with this. No? Yes, yes. Mentions any. Yes.
So that I like to mention for listing mallet of content matter mallet. It is 24 letter mallet. So mallet on 18 mallet.
No, not on 18. 28th.
28
November.
Wait, please, your lordship. My lord, I have filed a urgent writ petition today, my lord. Matter related to transfer, my lord. The petitioner here, he was a, my lord, grade 4 employee. He was promoted to junior assistant. And he has joined in that post. Now he has been replaced by the my lord private respondent through transfer, my lord. And he has not been posted in any other post. My lord. Today, my lord.
Yes, today. 2 o'clock.
My lord.
Yes.
May I please, Your Lordship? I'd like to mention item number 35 of your Lordship's list. In this case, it was fixed for final argument, but your Lordship had given a direction on the last occasion to furnish the books and judgments relied upon on a beforehand, which inevitably both of us overlooked, Your Lordship. A short accommodation to furnish that thing, any date may be fixed, Your Lordship, for that purpose.
4th of December?
No.
4th
Yes.
of December? 4th December.
Obliged.
8 with the lordship.
The request of council for point request based on 4th of December. 35.
8 with the lordship. My lord, I beg to mention for posting of an urgent interlocutory application on Monday, my lord, pertaining to a communication we have to challenge by bringing this for my lord with Mama for
Monday.
my lord.
Wait, please, your lordship. Beg to mention one contempt petition, lordship. Contempt petition, lordship. It may be listed in the orders column any date in the next week.
No, 28th November.
May it please, your lordship. On instruction from my client, I want to withdraw item number 19.
19.
19.
On instructions received from the petitioner, council petitioner submits that the writ petition be permitted to be withdrawn. Accordingly, writ petition stands dismissed on withdrawal. Interim orders, if any, stand vacated. Pending ayes are also dismissed. Anyone for the respondent? Mr.
N.K. Sharma.
N.K. Sharma appearing on behalf of Mr. H.K. Das, standing counsel, Guwahati High Court.
Wait, please, your lordship.
Lordship, I beg to mention for listing of a contempt petition and a read petition, Lordship, for orders and admission.
28th
Lordship.
November.
Obliged,
Going
Lordship.
for listing of a fresh motion on Monday.
When was it filed?
Yesterday, it was filed.
May I please your Lordship, with the consent of the other side, I beg to mention item number 1. Lordship, my senior, Mr. J. Roy is out of station. Lordship may kindly list the matter next week.
Item 1 and the request
Item
made
one.
by council on behalf of the
On 27th,
Mr. J. Roy, matter stands deferred to be listed,
27.
not 27,
Uh,
28th.
No, Lordship. No, Lordship, 2nd December.
In the first week of December.
Lordship, another item, item number 5. Lordship, there is a contempt matter arising out of the same writ petition, which is listed on Monday as item number 2. Lordship, both these matters may be connected, may be tagged on Monday.
Item 5, it is submitted, writ petition, connected writ petition from which the contempt petition arises, listed on Monday. Prayer is made to have the contempt petition listed along with the writ petition on Monday. What is the number?
Item number 2, content case.
What is the number of the writ petition? Strike out corridor, item contempt case stands deferred to be listed after 1 week. Yes,
May I please your Lordship? Lordship, I beg to mention item number 14, Lordship, only adjourned for the day, Lordship.
item 14 on the request made by the council for the petitioner stands deferred. Be listed after a week.
Highly of list.
May I please, Lordship? Lordship, I beg to mention for listing of WPC for hearing.
WPC for hearing, it will come for orders first.
No, Lordship, actually the matter was listed on yesterday, but court was not sitting and it was.
Will
for
you come
hearing.
for it? Will it be for orders? What is the matter? What is the subject matter?
Lordship, it is a pensionary benefit relating to pensionary benefit. We have challenged the VRS.
List on 21st for orders.
Orders.
I appreciate, Lordship. Lordship, I'm staying for listing of a writ petition for motion on Monday, Lordship.
When was it filed?
On 10/11/2025, Lordship.
10/11,
Yes, Lordship.
Monday, subject to clearing of defects.
May it please your Lordship, Lordship, with the consent of the other party, I beg to mention item number 28, Lordship. Lordship, settlement talks have been underway, in this matter, Lordship, so matter may be adjourned for 2 weeks.
Item number
28, Lordship.
28. 28 on the request made on behalf of the petitioner.
Lordship, for the respondent in the arbitration petition and for the applicant in the IA, Lordship.
Matter stands deferred to be listed. Again, after 4 weeks, as it is submitted that some settlement parties are trying to resolve the matter out of court.
May I please, Lordship? I beg to mention for listing Lordship, WBC Lordship, merely mention matter Lordship, next week Lordship.
When was it? It's a private matter.
Lordship, pending matter Lordship, 24 matter.
19th.
Lordship.
Lordship, I beg to mention a hearing matter for listing. Lordship.
Will come for orders. 28th.
Obliged.
Yes, for orders.
May I please, your Lordship? Lordship, new matter, your Lordship, I am seeking posting on Monday, your Lordship. New matter, your Lordship, I am seeking posting.
When was it filed?
It was filed on 12/11/2025.
12/11, it should come Monday, subject to clearance of defects.
Yes, Lordship. Lordship, I beg to mention WPC number 3804/2025 for listing for orders.
28. 28.
Yes, Lordship.
No, this is a contempt petition, Malad, your Lordship order is eight,
Where is the order?
page 8, operative part. Page 13, directed the authorities to consider the pending representation within a
But
period.
counsel for parties are being agreed by the willful disobedience and non-compliance of the directions contained in the order. So contempt petition has been filed, issue notice, returnable 4 weeks. Steps of the respondents by registered post within 1 week from today.
Yes.
Placed after returnable date.
Item 3.
May I please, your lordship. Lordship, order is at page 8 and operative portion is at page number 11, your lordship. Para 7.
Same order, heard counsel for party, we should notice. Returnable 4 weeks, steps on the respondent by registered post within 1 week from today. Placed after returnable date.
Much obliged, your lordship.
4.
This is non-compliance of the order, my lord. Lordship will see at page 21, my lord. This
Page number,
page number 21, the order passed by this honorable court, my lord. Operative part, my lord.
but was any time frame? given?
No, my lord, no time frame, my lord, is going to be 1 year, my lord. So after 1 year, my lord,
For party, we should notice. 4 weeks, steps on the respondents. By registered post within 1 week from today. List after returnable also.
Item 6.
May I please, your lordship. My lord, the amended read person, my lord. So, my lord, the Covert case, my lord.
Huh?
This Covert case, my lord.
Covered
Yes, my lord. WPC 342, my lord.
by which order?
My lord. Ordered is 3425, my lord.
Page number?
My lord, it is not annexed here, my lord.
Huh?
My lord, this judgment, my lord, passed earlier, my lord. Honorable Justice, my lord, Michael.
You should enclose it, bring it by way of an affidavit.
It cannot be covered, lordship, because
Uh,
this is filed in September 25, lordship.
Then
No, no,
You-
earlier it was filed, my lord, but it is amended, my lord.
you bring it on by way of an affidavit, that judgment which you want to rely on. Bring it by way of an affidavit. You should have referred these judgment.
Yes.
Bring it. Mr. Chauhan is counsel for the petitioner. He is permitted time to bring on record the judgment passed by coordinate bench, which he submits, has decided similar issues, and this writ petition can also be disposed of in terms of the said order. Let the matter be listed after
2 weeks.
2 weeks. US Ember state.
Obliged.
Item 7.
Right.
This is with regard to grant of benefit under the old pension scheme. They were initially, my lord, in the list of this 4,400 people, but then ultimately benefit has been only given to around 1,300 odd people. Similar repetitions are pending, my lord. Annexer 16, my lord, page 163.
मोहन मंडल भी है ना मोहन मंडल भी है ना आपका ही
Page 163, WBC 242 and 24 of 2024. This is the lead case and other connected matters are also there, my lord. Page 170 is the order.
Yes, madam.
Lordship, notice may be issued, Lordship.
Third counsel for parties. Claim of the petitioner is that they ought to be covered under the old pension rules. When similar benefits have been given to other similarly situated persons. So, in spite of their grievances being ventilated before the department, no steps have been taken to redress their grievances being agreed to, the petition is filed. issue notice within about 4 weeks, and it's B. Sharma. Turner CGC appears on behalf of all respondents. Since the CGC represents all the respondents, notices are waived, extra copy will be furnished within a period of 1 week from today. Matter be listed after the return date.
Complex.
Please, your lordship, in the present matter, the petitioner is aggrieved by order dated 22nd of May 2020, my lord, which is in Annexure 7, page 37, my lord, where his period of absence from duty has been treated as dice on the principle of no work, no pay, my lord. And this shall have a detrimental effect at the time of his retirement for obtaining his retirement benefits.
What is this order?
Lordship, page 30, Annexure 7, page 37, my lord. He was dismissed from service in 2016, my lord, on account of him being against.
It was interfered with.
Yeah, my lord.
Dismissal order was interfered with.
Yes, my lord.
He was reinstated in service.
Reinstated in service, but with the condition of dice on the principle of no work.
Where is the order of the High Court?
My lord, High Court order is in Annexure 3, page 22. Relevant portion is in page 30, my lord. Paragraph 22. In terms of this order, my lord, he was released from jail on 25th of May 2019. Thereafter, he submitted an application for reinstatement.
Hello, at this please notice my my lord.
All right, heard. Counsel for parties issue notice. Returnable 4 weeks. Mr. Ardhor, learned. National seeking of an advocate. 3 years and accepts notice on behalf of all. All?
Yes, my lord.
All?
Yes, my lord. All police, my lord. Yes.
All the respondents. Therefore, in the way that step up will be furnished. Within 3 working days. So it's after retirement.
My lord, the petitioner's salary has been stopped by the Joint Director of Health Service, my lord, page 16. Because she's my lord, party in the DRT case as she was the guarantor of her husband's loan. And the DRT, my lord, has directed to deposit 16,000 per month from salary to the Joint Director of Health Service. But my lord, he has neither deposited with the DRT nor paid my salary also. Rest of the salary I have not been paid. He has totally stopped the salary from May, my lord, 24.
Who's for the respondent? Yes.
Lordship, appearing, Lordship, at this stage, Lordship, notice may go, Lordship, because
Third counsel for parties issue notice written in the forwards. Who's for the health?
I'm appearing on behalf of Mr. D. Upamanyu.
MS so on behalf of B. Upamanu. Here's on behalf of respondents 1, 2, 3.
4, I'll
Mr. H on behalf of 4. And anyone for 5 and 6?
Only 5, Lordship.
So appears for respondent 5 steps on respondent 6 by registered post within 1 week from today. List accordingly.
But pendency shall be bar for processing the.
Not a bar at all. Anyway. I can tell. Teacher, you can advise her, so we will. Yes.
Lord, this is regarding compassionate appointment, my lord. My case, this is regarding compassionate appointment, my lord. My case has been rejected by the DLC. Page number,
Have you submitted in terms of this executive order?
no, my lord. Recently, DLC rejected my case. My lord, page number,
Recently?
after the judgment of 3-4, he approached the DLC. DLC rejected
rejected.
on August
No,
2025.
no, after what judgment?
After the judgment rendered in WBC
report.
342 of 2025 on 3/4/2025.
Justice Michael's judgment.
Yes, Your Lordship. In terms of the judgment, his case was placed before the DLC. DLC rejected due to want of vacancy.
page number 36. my lord.
Do you have a copy of the judgment here?
My lord, I have,
Give us a copy of the judgment.
He do that online.
Where is the order of the DLC?
my lord, page number 36. Page number 36, last row, my lord. My name is there. In the right hand side, my lord.
Inspector of Schools. Which one?
My lord, page number 36, last row, my lord. Last. Bottom page number 36, my lord.
Page 36.
36, my lord.
Serial number?
2, my lord.
2. Kabir Ahmed.
My lord. Right hand side, my lord, deals, decision of the deals.
Now then what happens to the notification? 18-9?
89, in my case, already was set aside by this court, my lord.
Set aside. Not set aside.
My lord,
The court has said we are not going into the merits.
my lord,
So the notification remains.
my lord, thereafter, my case has been rejected.
That is what we are asking you, when the state government has issued a notification
Madam.
saying that no more compromise, but
Madam.
under orders of the court, it has been reconsidered.
My lord,
Now what is to be done?
my lord, reconsidered and rejected due to lack-
Rejected. So,
rejected.
but the state government notification is already there. Only in the instance of the court, it was reconsidered again.
My lord,
The notification says no more compassionate appointment.
My lord,
That notification you did not challenge.
that case, I have challenged, my
You
lord.
challenged, but it was not answered. So the, what has to be, how is the notification to be appreciated by the court? There is a notification by the state.
My lord.
Either it has to be declared to be contrary to law, or you have to follow it.
Now, my lord, I am challenging
You are challenging it.
minutes.
In the face of the notification, you say that the notification has no role, has no application in the facts of your case. That is not your ground. There is a notification
My lord,
that was not interfered with by the courts.
my lord,
Yes? So the notification continued to operate.
my lord.
Simultaneously, the court said, we are sending it back. Let the DLC, SLC, whoever will redecide.
My lord.
It was decided and it was disposed of. Now, unless the government withdraws the notification, modifies it, or the court interferes with it, it remains. In terms of the notification, you are not entitled for compassionate appointment.
Now, my lord, the impugned resolution I have here in challenges.
You have challenged,
My lord.
but what is the ground of challenge?
My lord, ground of challenge, my lord, there is a vacancy, my lord. Page number 44, my lord.
No, but the notification says no more vacancy.
My lord,
The court did not give liberty to come to the court in the event your representations are rejected. There is no specific liberty.
my lord.
Court did not interfere with the notification.
Mhm.
What is to be done?
In the similar case, my lord, notice has already issued. In the similar case, my lord.
Maybe.
Similar, my lord, similar.
We are not inclined to issue notice, but if you want, we can connect it to that case. What is the number of that case? You have a copy of that?
My
order?
lord, my lord.
Give it to us.
One four. Same, my lord, same DLC, same ground of rejection, my lord.
Can to withdraw this. You are not inclined to issue notice. We can direct the registry to list this matter along with this WPC. This can't go on like this.
Okay, my lord. Will,
Third, learned counsel for the parties, this writ petition is filed, putting a challenge to the orders passed by the DLC in the district of Kachar, rejecting the case of the petitioner for consideration for appointment on compassionate ground. The DLC held that in the absence of any vacancies under compassionate quota, appointment for compassionate, quota for compassionate appointment, DLC rejected its proposal as it spent its force as per principle 10 in the OL dated 1/6/2015. Stop. Petitioner being aggrieved has approached this court. Petitioner has also referred to an order passed by a coordinate bench dated 3/4/2025, passed in WPC 342 of 2025. This order was passed by a coordinate bench. The writ petitioners, what is your case number there?
my lord,
The writ petitioner had also approached this court and in the earlier round of litigation, and his writ petition and the writ petition filed by the present writ petitioner was also disposed of in by this order, whereby bunch of other writ petitions came to be disposed of. Stop.
690/25, my lord.
Lihilo Wagor writ petition 690 of 2025. This court, upon consideration of the matter and the judgment of the apex court rendered in Debobrata Tiwari and others, closed these writ petitions with the following directions. Para 9, 1, 2, 3, 4, and 10. Stop. Para. By the say, in terms of the said directions, the writ petitions were closed. However, the correctness of the office memorandum dated 18/9. 18/9/24 was, although challenged, was not answered and decided on merits, and the matters were remanded back as it was on the basis of the consent given by the respondents for a fresh decision in the matter. Stop. Para pursuant thereto, the matter was decided by the DLC and the impugned and by the impugned minutes, case of the petitioner stood rejected. Para. The fact remains that by notification dated 18/9/2024, government has announced its policy not to provide for compassionate appointment or appointment under compassionate ground any further. Stop. Although these notifications were challenged, notification was challenged in this bunch of writ petitions where the lead case is WPC 342 of 2025. The same was not interfered with, nor was the correctness of the notification answered. Stop. These bunch of writ petitions were closed on the consent order, on the concession given by the states, and accordingly the directions in para 9 and 10, the state judgment was issued. Stop. As such, the notification dated of OM dated 18/9/2024 is still in force. And consequent thereto, two other executive orders were issued by the state, being 3008/25, whereby particulars of all the persons seeking compassionate appointment were called for, and the last date of which has now been extended to 31
Your Lordship,
31 December.
not 31st December. With effect from 3/10/2025, Your Lordship. This is the order.
Extended to which date?
With effect from 3/10/2025 for 3 months. So
They've
from-
been extended with effect from 3/10/2025 for 3 months. So under such circumstances at this stage, it is seen that the prayer in the present writ petition is for setting aside the resolution adopted, resolution of the DLC Achar in its meeting 16/8/25, whereby the claim of the petitioner stood rejected. And a further direction to the respondents to reconsider the case of the petitioner before the DLC in terms of OM dated 1/6/2015. Stop. This OM 1/6/2015 has already been superseded by the OM dated 1/8/19/25. 19/24. Stop. Under such circumstances, this court at this present stage is not inclined we should notice in the matter. However, as it is pointed out by the counsel for the petitioner that in a similar writ petition, being WPC 6124 of 25, the coordinate bench had already issued notice. This court considers it appropriate to direct this matter to be listed along with WPC 6124 of 25. List accordingly.
Right.
Which of the petitioner is a convergency Safai wala posted at Jorhat Station Cell is a civil defense employee. He has for the last 26 years he has never been promoted. He has completed the National Trade Certificate and Farm Machinery Certificate. Now for transfer, there is a policy for transfer, inter-cadre transfer to the MES department, where examinations are held for promotion. Lordship, I wanted promotion. I had made representations that has been rejected at page 30 and page 28. They say that I am not a regular. However, I have a service book. I have been granted quasi-permanent status, and the policy does not require regular.
All you should notice it.
Yes.
Mr. Bora. BP Bora for the petitioner. Mr. S.S. Royal and FCGC appearing for all the respondents. Let notice issue returnable 4 weeks since Mr. Roy represents all the respondents. Notices are waived. Extra copy will be furnished within a period of 1 week from today.
Well. May I please approach? Malad matter relates to Malad promotion. Petitioner before lordship is serving Malad grade 4 and he is praying for Malad promotion from grade 4 to Malad grade 3 Malad. His service Malad governed under Malad Assam Secretariat Subordinate Service Rules 1963. But before Malad amendment, before amendment the rules, he has passed the Malad is a requisite qualification, that is Malad higher secondary. But the Malad authority concerned rejecting his prayer. So Malad we are before this honorable court. Malad that impugn letters lordship may find at page 58. Malad, page 58.
58.
Yes, Malad. Annex 12. With reference to the letter under reference, I am directed to inform you that in the selection committee meeting held on so-and-so candidates who have passed higher secondary prior to 2012 were selected, and since you have completed higher secondary on 11/9/2012, you were not selected for promotion. And another one is there, 59 page. Herein mentioned that with reference to the above, I am directed to state the promotional avenue is provided by taking the vacancy position of calendar year, that is 1/1/2011 and 1/1/2012 in the incident case. You have, however, passed higher secondary examination on 12/9/2012, and thus as per the selection committee meeting held on so-and-so, you were not eligible for promotion as per pre-amendment rules. And subsequently, another letter has been issued, Malad. That is, in inviting reference to the letter on subject cited above, I am directed to inform you that the matter relating to your request for promotion to the post of junior administrative assistant has already been disposed of, and the letter so and so. But this is the reason. But earlier occasion also, one petition was filed in before this honorable court that lordship may find page 34. Page 34 onwards, Malad.
34.
Yes, Malad. The petitioner name is Malad, serial number 5, Bhavesh Dekha. The relevant page, Malad, 39. Operative page, lordship. Page 39, Malad. Paragraph 12. Paragraph 12, Malad. In view of the above, the writ petitioner is disposed of, directing the response to consider the following: whether in view of the fact that the vacancies in question have fallen vacant prior to the amendment brought on 2010/2012, the same would be governed by the pre-amendment rules, Malad. Whether the respondents were required to hold the selection every year or could club the vacancies in a single selection, depending upon the outcome of the consideration of the case in the above manner, the further course of action will be undertaken. In light of this, my lord, order, one official order has also been passed. That is, lordship may find page 56, my lord. Annexure 10, my lord. Page 56. Seen both the order of the Honorable Guwahati High Court dated 27/11/2014 and 22/4/2015 passed in WBC number so and so, that views of Judicial Department obtained in this regard is also reproduced below. It appears that the posts which fall vacant prior to the amendment, that is before 2010-2012 of the rules, will be governed by the pre-amended rules. As such, the vacancies which arose from 2011 till 1910-2012 are required to be filled up from amongst the persons who are eligible for promotion under the pre-amended rules. The department may consider the case of promotion in respect of vacancies arising each year separately in accordance with law. The department may take steps for complying with the order of the Honorable.
Today you get no instruction.
Okay.
Mr. Radhakrishnan. That's senior government advocate, the additional senior government advocate, yes.
1, 3, 4 and 5, my lord.
On behalf of respondents 1, 3,
4 and 5.
4 and 5.
For finance, my friend is there.
For respondent number 2. Since the respondents are represented, notices are waived. Extra copies be furnished within a period of 1 week from today. List after returnable date.
Obliged.
May I please, your lordship? And this matter is relating to selection and appointment of Anganwadi worker and helper. My lord, in terms of an advertisement, we participated in the selection process. The selection committee lordship prepared panel and the CDPA concerned lordship has forwarded the proposal to the director for approval. That approval lordship has not been given till date, and for which no selection list, no appointment has been made. Lordship, at this stage, lordship.
Get the instructions first. Let us see what.
Yes.
Petitioner is agreed that the selection process for appointment of Anganwadi worker or helper,
Both lordship, workers and helper.
you are applying for both.
Yes, lordship, 4 petitioners.
Workers, Anganwadi workers / helper. Under the Lala ICDS project in Hailakandi district. Pursuant to the advertisement dated 4/3/2024 has not been completed. Both the petitioners have offered their candidatures in response to the advertisement. Stop. Since the selection process has not been completed by the authorities, the petitioners are before this court. Considering the submissions made, let this issue returnable 4 weeks. Mr. D. Bora, government advocate, represents respondent 1, 3, 4, and 5. MSA Botaku for respondent 2. Since the respondents are represented, notices are waived. Extra copies be furnished within a period of 1 week from today.
Obliged.
15.
Also, the petitioner lordship, he is a graduate lordship, and he is seeking appointment as the in-charge Gaon Pradhan, because the post which was held by Zainal Abidin.
Nephews
Please, I'm the
are
nephew.
also given the benefit.
Lordship.
Nephews.
Lordship registered as lordship, it's clear. And lordship page 22, lordship this preference clause is there, page 22, lordship. Executive instruction, page 22. preference shall be given to the family members of Gaonbura and views of the Mojura
Page
shall be
22, page
of the-
22,
These are
Page
the
22.
qualifications.
of the notification dated 10 for
Notification.
2018.
selection board, page 22 is selection board.
Also page 22 may kindly say, this is the notification of 10 for 2018.
10/4/2018
Yeah.
notification starts from page 21.
Yes,
Yes,
page 22 are the relevant
Page 22
portion.
also,
Uh,
Roman 5.
Roman 5, okay. Preference.
Preference also. And in Lordship, the entire Assam Lordship where the selection process has taken place, they have given, they have earmarked 10 marks for Lordship family members. I am knowing Lordship other cases in the DLR Lordship. Given 10 marks is allotted for this purpose Lordship. Under the
This is
preference clause.
contrary to Article 14. How?
Lordship. Yes, my lord.
Why
Other
preference?
yes,
Lordship,
Why preference to family members?
yes, my lord.
this is the executive instruction Lordship.
Needs to be interfered with.
In entire, this is followed Lordship in entire Assam in the selection process. 10 marks given for preference for family members and 5 marks for in-charge Gaonpara Lordship. 15 marks.
Even if you're never interested or exposed to any Gaonbura activities, by virtue of the fact that you belong to the family member, you are given preference.
This system is followed Lordship.
It's not a good system. Yes.
Lordship, according to me, your lordship, other criteria has to be fulfilled, then only preference will come. Then otherwise it will be in violation of Article 14, my lord. Let me take instruction, my lord, because my, this one, the private respondent fulfilled the other criteria. It seems he is 10 pass, which is the minimum criteria. Even because his MA, your lordship, it will not like
No,
Next.
I am BA. I'm
BA or MA or whatever. And regarding the family members criteria, let me take instruction on what basis you were selected, your lordship.
Lordship, the Gaon Pradhan Lordship, they need to require, they,
What is the stage of selection? He's selected.
no, this is for
Lordship.
in-charge.
Huh?
In-charge, no regular selection has taken place.
Yes, and it is of 23/7/2005. Lordship, I'll take instruction a week or 2 weeks time be granted.
Mr. S.K. Das for the petitioner, MSP Priya, senior counsel, assisted by MS
Ardas,
R. Das, appears for respondents 1, 2, and 3.
Lordship, BTC.
The grievance of the petitioner will go to score the preference specified in clause 3 within bracket Roman 5 of the notification dated 10th of April 2018 issued by the government of Assam Revenue and Disaster Management within bracket LR department. Stop. The counsel for the petitioner submits that the petitioner offered his candidature for selection of Gaonbura, but as on date, the order for in-charge Gaonbura has been issued in respondent number in favor of respondent number 4. Stop. The petitioner claims to be the nephew of the former Gaonbura, namely
Joinal Abedin.
Joinal Abedin, and therefore the preference as specified in the notification dated 10th of April 2018 ought to have been given. The same not being done, petitioner is aggrieved and before this court. Let the respondents complete their instructions. Meanwhile, but then private respondent is there, we'll have to issue.
Yes, madam.
Possibly issue notice.
That the in-charge Gaonbura is arrayed as respondent number 4. The court considers it appropriate to issue notice at this stage. Let notice issue, returnable 4 weeks. Respondents 1, 2, 3 being represented by counsel. Notices are waived. However, extra copies be filed within a period of 3 working days. Steps on respondent 4 by speed post within 1 week from today.
Obliged.
Also, in the meanwhile, also my representation may be disposed of. Also, guys. 27
The reduction should not be a bar to consider and dispose of the representation stated to be by representation by the respondents. Which respondent?
No, by the petitioner.
No, to whom?
Who will,
did you
who will
file?
dispose it of?
Lordship, I have submitted to the chief executive member, BTC, then Director of Land Record Service, BTC Kokrajhar, and the circle officer, all the respondents. Sir.
What is the point in directing all respondents to dispose of your representation? Give us.
Because the appointment order was issued by the Director of Land Record
Direct,
Service,
so
BTC
we direct-
Kokrajhar.
Respondent number 2
First.
to dispose of the representation filed by the petitioner.
Lordship, may kindly give a fixed returnable date. Lordship.
It will be in January,
January.
7 January. 7 January. We have issued notice.
Item 16.
16, 17, 49,
39
are similar matters.
Huh?
Supplementary list 39 to 41 are the similar matters.
16, 17, 39, 40, 41.
Now, what is to be done here in this matter?
We have filed affidavit, Lordship. We have objected to.
In which matter?
In 39.
39, Lordship.
39 and 40.
40.
39 and 40.
Yes, Lordship.
So you are saying which matters? 39,
39
40,
and 40.
41.
41.
39, 40, 41.
Yes.
Lordship.
Similar matters.
All similar, 16, 17, 39, 40, 41. In 39 and 40, they have filed their affidavit in opposition. We have filed our reply, Lordship.
So the legal issues are similar.
Absolutely similar out of the same advertisement, Lordship.
All right, 39, 40. 39, 40. Yes, what is their objection?
Lordship, they are saying the similar matters has been disposed of by the Calcutta High Court, Lordship, but the Supreme Court says, Lordship, in our affidavit in item number 39, we have annexed the judgment, Lordship, annexed here, page 98, Lordship. Kindly see the judgment, Lordship. Delay. There are three. In facts and circumstances of the case, we are not inclined to interfere with the impugned judgment and order passed by the High Court. However, question of law is kept open for being considered in an appropriate case, and order passed by the High Court shall not be treated as a precedent. Here, Lordship, what had happened, Lordship? In PST, they have been disqualified. And 2D will come to effect at the detailed medical examination, where if BMIs are on, Lordship, then it will come, Lordship.
In these matters, the parties have already exchanged their pleadings, therefore. Which matters you have filed? Item?
Item 39 and 40.
39 and 40. Supplementary. Already exchanged their pleadings. Therefore, let these matters be listed for admission. Notice they made returnable within 1 week from today. Let notice issue returnable on 21st.
Lordship, in that case, Lordship, post may be kept vacant, Lordship, because their medical.
When are you likely to fill up?
Lordship, now that the initial state DM, after, if they qualify, Lordship, there will be detailed medical examinations are there.
How many posts are available?
That list is not yet.
Not yet,
published.
Lordship, published, Lordship. Lordship is fixing on
21st,
this month, Lordship. Then,
21st November,
21st November, it
next on 21st. In notices issued in item number 39 and 40.
yes.
Rest of the matters will be connected to item 39, 40. 16, 17, then
16, 17, 39, 40, 41.
16, 17 and 41 connected to item 39, 40. To be listed together on 21st of November. for admission.
I am appearing for 16, 17 and 40.
Mr. S.S. Roy and Ms. S. Borua, learned CGCs appears for these matters.
Item 18.
May page your lordship. My lord, may kindly come to page 60, my lord, impugn order
60.
601. Is the order dated 22/4/2016, my lord. Here is written that in pursuance of government order contained in so and so, the services of the following staff presently under the establishment of Joint Director Health Services Jorhat, who with fake appointees should be removed from their services immediately, my lord. And accordingly, we have not been allowed to work. And after this order, my lord, in this order, my lord, so many candidates are there. Many of them have filed a writ petition, my lord, which is pending before the honorable court and at the stage of hearing, my lord. My simple prayer is, my lord, I want a common hearing along with the writ petition, my lord. And after this, after page 60, my lord, may kindly come to page, next page, my lord. Page 61. This is a letter dated 10 January 2017 from the Director of Health Services, and all the petitioners were asked to report before the director and submit their documents. All the petitioners have submitted their documents before the director, and thereafter nothing has happened, my lord, no inquiry, nothing else. And at this stage, my lord, they were waiting for an inquiry, but they came to know that WPC 2837 of 2017 by some other candidates have filed, and which is at the final hearing stage, my lord. Pleadings have completed. And I have made a prayer in the paragraph 10. I have stated about the repetition, and I want common hearing, my lord, along with the repetition, my lord.
Who's for the respondent?
Lordship, here I am appearing for the health department, Lordship.
All.
Finance was there. Finance. Yes, Lordship, I am appearing for all the respondents. Lordship may club this matter, Lordship, if with with WPC
2837.
This matters are fixed
2837.
for hearing.
Lordship, yes, it's a 2017 matter, Lordship. Now, my learned friend, Lordship, in the meantime, we'll verify, Lordship, if the petitioners are similarly situated also.
You
Lordship.
first verify and tell us.
Yes, Lordship.
My lord, these are identical. I have made a statement, my lord. Same-
Lordship, we'll have to verify, Lordship.
When are these matters fixed?
My lord, I think part hard, no? I think it is part,
Date has not been fixed, Lordship. It was listed.
part hard matter before just the honorable justice.
Lordship may issue notice in the meantime if some similar order is passed, that can be, my learned friend will be covered in that also. At this stage, Lordship.
I heard counsel for parties issue notice. Then we go. 4 weeks, Mr. A. Chalia represents all
the respondents.
all the respondents. Stop since the respondents are represented by Mr. Chalia. Notices are waived. Extra copies be furnished within a period of 1 week from today. Just after 4 weeks.
My lord, in the meantime, my lord, I will not get a chance of hearing, my lord, along
No,
with that.
Lordship,
When is the matter fixed?
there's no fixed date.
My
Is
lord,
it fixed on a particular date?
not fixed on particular date, therefore
Ah.
it will be tagged along with that matter, my lord.
So why are you apprehending that the matter will be heard in this one
Yes,
to
Lordship.
3 weeks?
My lord, this is a part hard matter, I am told.
Part heard matter.
Yes, my lord.
Part heard matter can't be tagged. You have to take permission from that court.
Fine.
You mentioned it before the court concerned.
Part hard.
Lordship, I'm not aware, Lordship.
You mention it before the court concerned and
Fine.
say that this matter be tagged.
Fine.
Please furnish him extra copy
Fine.
within 3 days.
Fine.
Supplementary promotion item 38.
Mr. Lordship, notice has been issued, Lordship, on 18/8. Respondent number 4 already appeared, Lordship. Kindly peruse the office note dated 12/11, Lordship. Matter is wrongly listed on Muslim calendar.
I don't know. Speak a little louder, please.
Notice has been issued, Lordship,
Ah.
on 18/8.
There is an office note where it says that unserved notice on respondent 1 and no AD card on respondent 2 and 5.
Matter is wrongly listed on
Wrongly
motion
listed.
column. In motion column.
Ah. Should come for orders. Meanwhile, what are you going to do with the steps? Do you want to take fresh steps?
Lordship.
This matter has been wrongly listed for motion. Notices were issued on 18/8/2025. So, office note dated 12/11/25 reflects that AD card on respondent 2 and 5 has not been received, and unserved notice from respondent number 1 with the postal note within quotes. No such address, comma, no department, quotes closed. Stop. Where under such circumstances, the matter be listed for orders after 4 weeks. The petitioner is permitted to take fresh steps on respondents' 1, 2, and 5. Steps be effected by registered by speed post as well as by usual posts within 1 week from today.
Hello, I pay for the respondent number
Mr.
4.
B. Sharma appears for
Respondent number 4.
respondent. 42. Yes, any instructions?
Lordship, we have taken telephonic instruction, but in writing it hasn't come. This one, town, what was that? Development authority is still in existence, dear Lordship. Lordship had granted the order of status quo. He is continuing as such.
Ah.
I will take in writing, your Lordship.
Mr. M.K. Chaudhary, Senior Counsel, assisted by Mr. M. Sharma, appears for the petitioner. MSB Bhuya, and the council represents the BTC authorities. Mr. C.K.S. Borua for
1 and 2, 1 and 3.
respondents. Who is 1 and 3?
1 is Housing and Urban Affairs and 3 is Town and Country Planning.
Respondents 1 and 3. So, MS Bhuya submits that our instructions are not complete. Whereof, accordingly, matter be listed again after 4 weeks.
After 4 weeks?
4 weeks. Meanwhile, the interim order passed earlier will continue.
Most.
What happened?
List again on 5th of December.
January? Oh, no.
January.
No, not yet. In December.
Let it be January then.
No, Lordship, in December. Dada took it away.
10th of December.
Lordship.
Yes.
Placed.
Oh, sorry. Item 44.
May I please, Your Lordship? This is a case, Your Lordship, where Your Lordship, the petitioners, Your Lordship, pursuant to a selection process initiated by the respondent authority vide advertisement, Your Lordship, at page annexer 1, page 18, Your Lordship.
1 minute.
Lordship.
Motion or last of material? Yes.
Lordship. Page 18, your lordship, annexure 1 is the advertisement, your lordship. Pursuant
No,
to
no,
which we.
what is your prayer?
Clear, your lordship, we have your lordship, in fact, what has happened, your lordship, in facts in nutshell is this, your lordship. When results are out, your lordship, we found, your lordship, when the answer keys were uploaded along with our answer scripts, your lordship, that we found that, your lordship, the petitioner number 1 secured 98, petitioner number 2 secured 96, and petitioner number secured 94 marks in, your lordship, written examination. And thereafter, your lordship, they were called for the Viva Voce, your lordship. There is a Viva Voce and the skill test, your lordship, 10 marks each, your lordship. And when the final results were, your lordship, out, our names were not there, your lordship. And ultimately, your lordship, when we file RTI, your lordship, asking for our marks in the Viva Voce and skill test, they are not providing that also, your lordship. And the select list also, when published, final select list, your lordship, we don't know what is the cutoff mark, who gets what, your lordship. I have annexed the select list, your lordship, that your lordship will get it at page 42, your lordship, annexure 7, your lordship. Your lordship will find, if your lordship comes to the select list, it's only roll numbers are there, your lordship, what marks who are obtained by him. Total, your lordship, transparency has not been adhered to, your lordship. Even then, your lordship, we are at least entitled to know how many marks after, your lordship, securing 96, 98, 96, and 94 in your lordship written examination, your lordship, not being selected.
Your roll numbers are not there.
Not
in the
there.
select list.
Not there. And in fact, your lordship, we have filed RTI also, your lordship, seeking our names before coming to this honorable court, your lordship. That has also not been provided by them, your lordship. So that has forced us to come before this honorable court. Had they provided us, your lordship, we have specifically asked for certain information, your lordship. What was the cutoff marks you have in the particular select list? Those are also not been provided, your lordship.
Lordship, I have received telephonic instruction, Lordship. They have secured 98, 96, and 94 marks, Lordship, in the written, but there were 10 marks for Viva and 10 marks for skill test, Lordship. So in total, it was out of 120, Lordship. And the petitioner number 1 who secured 98, he has fallen short by just by 1 mark, Lordship. So the cutoff was 110 as per my telephonic instruction. So, Lordship, notice may issue, Lordship. May issue notice, Lordship. I'll file my affidavit, Lordship. Because I have my.
Mr. S. Petitioner. Petitioners are agreed that in spite of securing high marks in the written examination conducted for appointment to the recruitment to various grade 3 non-technical under the establishment of the Directorate of Medical Education, Assam, petitioners have found their roll numbers in the select list, which is published. So it is submitted that the select list, which is published on 14/9/25, only reflects the roll numbers without the marks obtained. Stop. This, according to the writ petitioner, does not this according to the writ petitioner this according to the writ petitioner is a step ought not to be taken by the respondent, as it affects the transparency but to be maintained by the authorities concerned. Stop. In spite of applications filed, the marks secured have not been furnished. Being agreed, we have approached this court. Mr. D. Upamanyu, learned counsel representing the health, submits that you would like to complete instructions in these matters. Stop recording. This notice issued returnable 4 weeks. Mr. D. Upamanyu accepts notice on behalf of respondents.
For all the respondents.
Therefore, notice is away. The extra copies will be furnished within a period of 1 week from today. List again after the returnable date.
Your lordship may fix a date, your lordship, if they file affidavit, your lordship can dispose it of, your lord.
5th of December.
Lords. Highly authorized. 45.
May I please tell us? From last occasion, instruction was sought for lordship.
I have received the instruction receipt. Yes. It is reversed. Against the order of Honorable Single Judge Lordship, appeal has been filed Lordship before a division bench Lordship. About. And there are some delay, so notice has been issued Lordship.
Bill has not been admitted yet.
In para C, they have mentioned his Lordship.
Where is the order of the the coordinate bench?
Lordship, annexure 5 lordship,
126 page.
yes,
Yes.
126, relevant person 156. 156, there are 18 onwards. Lordship. Order starts from 126 lordship.
One
26 lordship,
26,
yes. And relevant person 156,
156.
yes.
Yes.
Paragraph 18 onwards.
Hmm.
Delegation, no?
You are all serving as what?
Lordship, earlier we are working 175 battalion lordship, and at present in different
In
battalions.
what capacity?
Lordship, different person of different capacity lordship. I have mentioned in the.
Rafiq
first
Pashi is
lordship,
normally for grade 3 and 4.
but all are under grade 3 lordship.
Grade 3.
Yes, lordship.
That is what we are asking. All right, then let us await the outcome of the appeal.
So then till that start on.
Ah. Heard learned counsel for the parties, the petitioners are agreed that the risk and hardship allowance which were paid to the petitioner for the period February 2019 to January 2023 was sought to be recovered by the respondent authorities by which order?
125 lordship.
By the order dated 22/5/2025 on the ground that excess amount was released to the petitioners. Stop. These petitioners are presently serving as, you're serving as what?
Yes, lordship. CRPF cadre lordship under 175 battalion.
Presently, some of them has been posted in different places.
I have mentioned the cost title lordship details list.
Petitioners are all employees of CRPF
Yes.
serving in various battalions or units. All in Assam or elsewhere? All in the state of Assam.
Earlier at state of Assam, while they are serving under 175 battalion lordship, at present different state.
Stop. While they were serving in Assam as a part of 175 Battalion CRPF, the benefit of risk and hardship allowance for the period February 2019 till January 2023 was released, which now by the impugned order, they are seeking to recover it. on the ground that excess amount was paid. The learned counsel for the petitioner has referred to a judgment passed by coordinate bench in WPC 2828 of 23 and other connected writ petition, which came to be disposed of by order dated
22/5/2024, Lordship. 22/5/2024.
22/5,
2024.
2025,
24, Lordship.
24,
Yes, Lordship.
22/5, 2024, stop. Whereby the claims of the petitioners therein were allowed and the recovery sought to be made was interfered with by placing reliance on the judgment of Rafiq Mashi, whitewasher, rendered by the apex court, reported in so and so. Stop. Mr. Lokur, Learned CGC on the other end, on instruction submits that the Union of India has preferred an intra-court appeal in IA number
IA number 2443 of 2025.
2443 of 2025. The matter is presently under consideration before the division bench of this court on the for consideration of condonation of the prayers for condonation of delay. So it is submitted that the matter is still pending and no final orders have been passed. Well, taking into consideration the submissions made by the respective counsel, review that at this stage notice be issued. That I accordingly let notice issue returnable 4 weeks. Mr. Loper appears and accepts notice on behalf of all
Lordship.
all the respondents. And therefore, notices are waived, however, extra copies be furnished within 1 week from today. The counsel for both parties are at liberty to intimate the court about further orders being passed by the division bench in IA number so and so. So, until further orders, the impugned recovery sought to be made by the communication dated 22/5/2025 within bracket annexure 4, page 125 of the writ petition shall remain state.
Possibly is notice. In the meantime, epidemic filers.
Yes, you can find respondents are permitted to complete their instructions and file necessary affidavit. In the meantime.
46.
May I please allow, sir? My lord, the petitioner before your lordship, my lord, was a superintendent, my lord, of municipal board, my lord, in charter. And by mistake of facts, my lord, he was placed under suspension, my lord. Thereafter, my lord, DP was initiated. The facts remains that, my lord, I like to draw lordship's attention at page, my lord, at page 24. The actual owner of the shop house, my lord, made a complaint, my lord, that his shop has been taken away and false document has been made by the person, my lord. Thereafter, my lord, he has paid all the receipt, khazna and tax, everything, my lord. And false document, lordship will see at page 27, my lord. 28 is the signature, my lord, and 24 is the application for complaint, my lord. Thereafter, my lord, under the instruction of the higher authority, I made a preliminary inquiry, my lord. Thereafter, my lord,
Submit all these before the proceeding, disciplinary proceedings. Why do you?
I'm retired, my lord.
Huh?
31st March, I'm retired, my lord.
You're retired.
I have retired. 31st of May, my lord. And now, my lord, what
When
they,
is the
without following
proceeding
the,
initiated?
While he was in service, Lord. If
While you
Lordship-
were in service.
Yes.
No, I was in service, I was placed under suspension.
No, the proceedings were initiated while you were in service.
No, my
Or
lord,
after
it does
your
not
superannuation.
say so, my lord. Lordship will see the page 42, 41, last page.
Yes.
40 and 41 lordship can be seen. It is after my retirement, my. Page 40, my lord.
Oh, where is the notice?
34, page 30,
Suppose.
page 34.
Initially, it was, my lord, page
Then you were in service. Page 34.
34, I was in service.
Then.
And now, my lord, after my retirement, my lord, all these things are going on, my.
But
Page
show us
40
an
and
authority
41.
that after you retire, the disciplinary proceedings are to.
My
be
lord,
closed.
the proceeding, departmental proceeding, there is a altogether, they have established procedure, my lord. Now, my lord, the person who has tampered with the document, he has been asked to appear, my lord. Page 41 be seen, my lord. Some Rija Ahmed. And who is, my lord, she has tampered the document by herself. An original owner lost and complained.
What is your prayer now?
Prayer, my lord, I am challenging the departmental proceeding, my lord.
Why?
My lord, because it has vitiated, my lord, in all the process, my lord, inquiry and all the thing, my lord.
We'll see that. Heard Mr. J. Barboya, learned counsel for the petition. Petitioner is aggrieved by the department proceeding initiated by the petition. By the show cause notice dated 10/3/2025. While the petitioner was employed under the Guwahati Municipal Corporation. Subsequently, the petitioner superannuated from service, but the proceedings are still underway. According to the petitioner, the entire proceedings are initiated at the behest of but you say it is at the behest of this Riza Ahmed.
My
You not arrayed him the person a party?
I'm not seeking any relief against that person.
But your basic ground is that it is on the basis
My
of
lord, lordship issued the notice. In the meantime, I'll file, my lord.
on the ground that one is Srimati Riza Ahmed was responsible for interpolation of documents which the petitioner claims to have detected.
I have annexed also, my lord.
And because of that, she has managed to influence the respondent authorities to proceed against the writ petition. So he therefore submits that the entire departmental proceedings is mala fide and ought not to be allowed to proceed any further and should therefore be set aside and quashed. Mr. Nayak. Representing
All the other.
on the other end submits that the proceedings are on the basis of the rules and procedures ordered followed by the Guwahati Municipal Corporation and the claim of mala fide by the petitioner is disputed in the absence of any specific materials to support.
That is one lordship. He, in response to the so-called lordship, he submitted his reply also.
The petitioner, in response to the show cause notice issued, had also
I replied
submitted his
everything.
reply.
Yeah, he replied.
And therefore, at this stage, to say that the proceedings are being initiated for not bona fide reason is only unacceptable. Right. Considering the submission list, I issue notice returnable 4 weeks. Since Mr. Nayak already represents the respondents, notices are waived, extra copies be furnished within a period of 1 week from today. Since there are allegations made against one Srimati Riza Ahmed, who the petitioner claims had instigated the entire departmental proceedings for malafide reasons. Let the petitioner take steps to array the said person in the present writ petition. Why should we direct you to do that? Because
My lord,
you
I made
decide,
a statement, lordship,
No.
kindly see page 36.
since certain allegations are made against the said person, Srimati Riza Ahmed, according to whom the departmental proceedings have been initiated for not bona fide reasons. The petitioner will address the court on the next day whether effective orders can be passed in the writ petition. In the absence of
Only, my lord, one thing, my lord,
parties.
lordship can grant me liberty to file
We're
approval.
not granting you liberty, who's stopping you?
My lord.
You file the petition, you decide who to array parties or not.
Yes, yes, yes.
Why you
Lordship,
want liberty?
Fixing matter, my lord. Lordship is fixing matter date.
We are not fixing a date. We are giving a returnable after 4 weeks.
My lord, can it be a fixed date, my lord? 3 weeks,
date.
my lord, by this time I'll do the needful, my lord.
The 8th of December,
Lordship.
returnable on 8th of December.
Item 47.
May I pray, Lordship? It is, the petitioner, it is SCS officer, senior grade 2, Lordship. He is serving in as a joint secretary to the government under the BTC, Lordship. And there is a promotion while he was in service at Karbi Anglong, Lordship. 16 to 18, he was graded outstanding. Subsequently, he was received the award of Chief Minister Award for 1920 for his outstanding performance. In the year 2021, he was suspended in some false allegations. On the basis, subsequently that was revoked, and departmental proceeding against him was dropped. Thereafter, the petitioner was promoted to the post of grade 2 post, Lordship, SCS. And after that, he has been transferred to Borol and BTC in November 2024, Lordship. Now, after coming to BTC, Lordship, he has come to know about the promotion of some junior most officers without following any procedural law. He asked for before the authority to reason about that, but he has not denied to give any positive reply. Thereafter, they sought for an RTA, file an RTA application before the authority, but they have supplied the RTA application. I have, after going through that, Lordship, without any gradation list or anything, and without following any rule on Assam Civil Service Rules 1998, Lordship, the selection was made by the authority, Lordship. Although the petitioner under the zone of consideration, 11 page 68 is the minutes of the meeting held on 17 to 22. Now they are going to again promote some of the junior officers.
You are still in grade 2.
Yes, Lordship.
You want promotion to grade 1.
Grade 1. My juniors have been promoted to grade 1.
At this stage, we can only issue notice.
Yes, Lordship, and in the meantime, not to, again, if some other officer will be promoted, then it will
No,
be
once
very
we find
difficult.
that your claim is justified, we can direct them to give you whatever benefits are there in
Yes.
service. But
Yes, Lordship.
that we can always do.
Yes.
Heard MSN, the counsel for the petitioner. Petitioner is a civil servant employed under the government of Assam. And he is aggrieved by the fact that person's junior to the petitioner in the radiation list in ACS senior grade 2 has been considered and for promotion to ACS senior grade 1 with time scale, overlooking the claims of the writ petitioner. Stop. It is submitted that the petitioner is considered to be an efficient officer and has been awarded various accolades for performance rendered during his service tenure. Stop. However, overlooking the claim of the writ petitioner, several younger persons, junior to the petitioner, have been promoted to ACS senior grade 1.
Yes.
Senior grade 1.
Yes, Lordship.
Being agreed. the
Senior grade 1 time with time scale.
with time scale, senior grade 1 with time scale. Accordingly, we said the writ petition has been filed, challenging, seeking a direction from the respondents that his case be considered and all benefits be granted to him, all service benefits be granted to him from the date his junior officers have been promoted. Considering the submissions made, issue notice returnable 4 weeks. MS M. Bhattacharya, additional senior government advocate.
1, 2, and 3, Lordship.
Of respondents, 1, 2, and 3.
Yes, Lordship. Others are private respondents.
Therefore, notices in respect of 1, 2, and 3 are waived. However, extra copies be furnished within a period of 1 week from today. Steps on respondents 4, 5, 6, 7, 8, 9, 10 be undertaken by speed post as well as the usual course within 1 week from today. Respondents may complete their instructions and file necessary affidavit in the meantime. List again after returnable date.
In the meantime, not to promote any other person above the petition.
How does it benefit you? If your claims are protected,
yes, Lord,
are answered by the court, whatever benefits
obliged, Lord,
are entitled, you will get it.
obliged,
Obliged.
obliged, Lord.
Item 43.
May it please your lordship, my lord, I apologize for not being there personally, my lord.
No, you don't have to apologize. We have the facility of virtual.
My lord, I am thankful to your lordship, my lord.
Yes.
My lord, the person before your lordship is, and the previous day also I explained, my lord. He is a
person with
benchmark disability, my lord. He has been transferred to a far distance from his native place, Kamrup, Guwahati to Dibrugarh. Initially, he was attached to from Guwahati to Sibsagar, and he has been finally transferred to Dibrugarh despite several representations. Your lordship was pleased to grant an interim protection that no coercive action shall be taken against him. While we filed this petition, he was on earned leave because of the fact that his ailing parents and his wife had undergone certain surgery, and his mother was suffering from typhoid. He himself is a 45% disabled person, my lord, having benchmark disability, protected by statutes of this country and a constitutional guarantee, my lord. And that is why your lordship was pleased, my lord.
He granted you some interim order.
My lord, but that is what I am coming to your lordship, my lord. That after the end of my earned leave, I went to join there in Sibsagar again, despite all the difficulties. They accepted my this joining letter.
Just 1 minute. Yes.
They accepted my joining letter, my lord.
Hmm.
But at the instruction of the respondent number 4, that joining letter was again, my lord, reverted back to me saying that your joining will not be accepted. Now they have not paid my salary, neither they have allowed me to rejoin in Sibsagar. And they have, the respondent number 4 in his personal capacity has filed an affidavit. Whereas the affidavit from the government and the affidavit in official capacity of the respondent number 2 and 3 is required, my lord. Because I made respondent number 4 2 as a party, respondent as respondent number 4 in personal capacity. He filed his affidavit. That makes no sense. We need to, because there is a government scheme, my lord, so far as this kind of persons is concerned, so far as transfer of this kind of persons are concerned, my lord. And it is the government or the department concerned can answer the questions that I raised in these petitions. And there shall be some amount of response and respect to the authority of this court, my lord.
After you joined Sibsagar,
Yes.
after the order of Sibsagar was passed, posting you, you were not permitted to join there.
I joined, they accepted. Then very afternoon of that day, they reverted me back. My lord, on 7th November, I joined.
Where is that
morning, and in the evening, they released me from the joining.
Where is that order?
That, my lord, in last occasion, I showed to your lordship and I have taken it back. Perhaps it is not there, but it would be with the counsel for the respondent number 4, my lord.
Yes.
My
lord, respondent number 4, my lord, I don't know, my lord, the lordship, my lord, my learned friend, he made me party, my lord, as a respondent number 4, my lord, personally. So that is why I have to file the affidavit, my lord. So it is not that I am not that party and I without any capacity, I am filing this affidavit, my lord.
No, I am not disputing his right to file an affidavit. He has made a party, he will file an affidavit, but his affidavit may not be considered because it is the government scheme of the government.
You are representing respondent 2 and 4.
No, he cannot represent 2 and 4 together.
I want 4, my lord.
Only 4.
My name is.
Okay, what has 2 got to say?
Because basically, lordship, in 2024, he has been attached to the inspector of boilers of Sibsagar.
That is okay. When the matter is passed, we have granted some interim order. You have allowed him to. We did not stay the order of joining in Sibsagar. You passed an order. He went to join, and then you release him on the next day. Why?
My lord, may I explain, my lord, one thing, my lord? My lord, so far, my lord, interim order is there. My lord, initially, as per my instruction, my lord, initially, my lord, he given an impression to the, my lord, inspector of boilers in Sibsagar that this order of transfer has been stayed, my lord. But the so far, my lord, order is there, my lord, there is no any specific stay order. Only, my lord, not to take any coercive action. That means, my lord, that you are not going to any further on the not complying this order, my lord. But it does not mean that, my lord, he will be allowed to continue that post. And so far, my lord, so far his transfer order is there. That is on 9th. With immediate effect.
We want to understand one thing clearly. He was posted where in Guwahati earlier?
No. Earlier, initially, my lord, he was in Guwahati. Then, my lord, in last year, he was transferred to, my lord, the Sibsagar.
No, he was not transferred. He was attached in Sibsagar.
Let me complete. You come to your term.
No, transfer and attachment is different thing.
Let me complete. My lord, in that aspect, my lord, why he was transferred, his attached, my lord, that is also been explained, my lord, in this affidavit, because certain allegations were there against him. Because of that, my lord, he was supposed to transfer attached in this Sibsagar. And during that period, also some discipline proceeding also initiated against him.
What affidavit?
In my affidavit, my lord.
You have filed some affidavit?
Yes, I have filed it.
It is not here.
It is a file on, my lord.
It's not here.
It is on 12/11, my lord.
It's not connected.
It is as there.
It is not connected. We'll direct it to connect it.
My lord, in the meantime, my lord, I will also come up with a reply to that affidavit. And what my sincere prayer is, my lord, if lordship kindly hear for 1 second, my lord. My lord, my respectful and folded hand prayers, my lord, that he may be remained in Sibsagar where he was attached, and he shall be paid his salary. He is suffering from such a serious problem at his home, and his salary has been stopped, my lord. That is the punishment, and this is the course of action against the order protection given by this court, my lord.
Now, on a day when we initiated when we passed the interim order, you were attached to Sibsagar.
Sibsagar. I want to remain there. It's all right. Your lordship will decide it in a later stage when I should be brought to.
It's from Sibsagar.
My lord, he was immediately with effect on 9th, my lord, he was released.
Why?
Because my lord, he was transferred to regular transfer to Dibrugarh, my lord. Because of exigency of service and there is shortage of manpower. It is specifically mentioned, my lord.
But you are aware that the matter is being session of this court.
No. On that day, this is not there, my lord.
On which date?
My lord, this order was on, this is after order was passed.
When was the order passed?
Order was passed probably on, my lord.
31/10. The interim order was passed on 31/10.
The transfer order was on 9, my lord.
9 of
9 of 10th October.
9/10.
Yes, my lord.
I have challenged that order only.
So after, my lord, on leave, that to whenever he challenged the order, my lord, that is in leave. His leave petition was filed on 13.
No, but what understanding do you have of this direction of the court till the next returnable date? Take no coercive action.
Coercive action, my lord, if it is my lord state, then it's specifically state. My lord, coercive action means, my lord, as for my understanding is there, my lord, some further proceeding because he is not complying the order. So on that is my lord, so cause another thing that means my lord coercive action.
No, my lord, in my respectful submission, this is not the
order-
meaning of coercive action.
Understanding, how can you have any understanding like that without seeking a clarification from the court? If you want a clarification, you come and approach and get a
But
clarification.
they, in simple understanding, my lord,
No,
the
no,
coercive-
simple understanding,
He-
our understanding will be that you are trying to overreach the order of the court.
No, we have not overreaching, my lord. If
Then-
it is, my lord, then my lord, I'll maybe allowed to, my lord, I can allow him, there's no problem, my lord.
You are not doing the court a favor by allowing it.
No, my lord, is my understanding.
Your
simple-
attitude is that you have not understood, therefore you will do.
No,
as
my lord,
per
he's a
your
junior,
understanding.
my lord, he's a junior
When the
officer.
matter is pending before the court.
No,
when
I
the
am not
matter is
interfering, my lord,
pending before
anything,
the
my
court,
lord.
Mr. Monto, please listen to the court. When the matter is pending before the court,
Yes, my lord.
if you have a doubt, you are expected to get a clarification.
No, that
And
will, my
this
lord.
order is not an interim order.
It is only not to,
Indefinite.
only
This is
not to
till
take the
returnable
coercive action.
date. Till the returnable date, and a date has been fixed. And you did not have the good sense to at least seek legal advice as to what is to be done.
My lord, they, as
You
much-
are relying on your understanding.
no, my lord, they, whatever, my lord, understanding, my lord, is, my lord, if it is.
No, we will ensure that this understanding.
If it is my
not
lord, lordship,
modified.
my lord,
It
lordship.
appears to be
Then,
malified.
my lord, we can allow him to join, my lord. There is no problem, my lord. We can allow him.
You-
But thing is there, my lord,
There's no
like,
question of can. You have to.
no, I
You
allow,
have
my
to
lord. But
withdraw
one thing,
this order
lordship,
today, or we're issuing a contempt notice.
my lord, lordship, one thing have to be apprised, my lord, one thing. On the day of the, my lord, the stay order, he was not in there, my lord. He was not in there. Because he is transferred,
when were
kindly,
you informed of this order?
my lord, kindly see the
When were you
annexer.
informed of this order?
My lord, kindly see the annexer is, this annexer, page 42, my lord. Kindly see, my lord. His petition.
Yes.
This is, my lord, this is a clear order whereby it is with effect from 9th, he was, my lord, released from that. Direction was
Right.
given. Then, my lord, he came with a leave petition on 13/10. During that period, he never thinks, my lord, to be done anything, my lord. And 13/10 he filed, and the stay order was, my lord, this order, whatever, my lord, lordship has passed, and my lord, is not to take the coercive action. That is on passed on 13th, my lord.
H. Amwa, learned counsel for the petitioner. Mr. C.K.S. Borua, learned counsel appearing for the state. And Mr. P. Monto appearing for respondent. The petitioner before this court is aggrieved by his frequent transfers. The ground that he is the person with benchmark visibility, and therefore such transfers from across the state ought not to have been done considering his disability. Stop that apart, he claims to be the sole caregiver to his ailing parents and wife, spouse. So nevertheless, he was, from his earlier posting in Guwahati, he was transferred and attached in Sibsagar. Inspector of Boilers, Sibsagar. So
No, as well as senior inspector of boiler. Oh, no, yes, sorry.
then on 9th of October 2025, the petitioner was again transferred and posted in the office of the senior inspector Dibrugarh. Stop. It is this order that the petitioner thereafter filed his application before the authorities concerned, which according to the petitioner was not disposed of. Being agreed, he has approached this court. Whereas this court by order dated 31/10, on consideration of the prayers made, permitted the additional senior government advocate to obtain instructions. It was also made clear that pendency of the writ petition will not be a bar to redress the grievances issued by the writ petitioner by way of his representation. Stop. It was further directed that till the next date, department will not take coercive action against the petitioner in pursuance of the impugned transfer order dated. What is 2310? What orders were passed on 2310? Mr. Chomwa,
My lord,
what orders were passed on 2310?
ordered by, my lord,
Nothing.
In the last order, there's a reference of an order passed, transfer order dated 2310. What is 2310?
Nothing is here, my lord.
no, my lord, 2310. Not seen any order.
So, better. Thereafter, the matter was listed again on 10/11, on which date it was submitted by the council to the petitioner that he has not been permitted to join in Sibsagar.
And his salary is also stopped, my lord.
The matter thereafter is being posted today. Better. Today, Mr. P. Monto, the council representative respondent number 4, submits that an affidavit has been filed on affidavit has been filed before the court. The said affidavit, however, is not on record. The registry will trace out the said affidavit and place it on record before this court on the next date fixed. Stop. As it is submitted by the council to the petitioner, that petitioner has been released from Sibsagar to facilitate joining in Dibrugarh in terms of the transfer order 9/10/2025. This court, in the fitness of things, considers it appropriate to stay the transfer order dated 9/10/2025 and all consequential orders passed. Petitioner will be permitted to join in his place of posting till further orders are passed by the court. Any salary found payable to the petitioner, including current salary, shall be forthwith released. Orders be complied within 7 days from today.
My lord, one more thing, my lord. When this order dated 31/10 was passed, my lord, we went to office to furnish a copy of this order. They refused to accept, my lord.
On 8th of December.
My lord, one thing, my lord, because my lord, he is not in service on that particular date, my lord. So if it is joining in that area, so that is some time will be required to regularize that part. My lord. So 7 days will be, I think it will more earlier. So that way at least my lord, 2 weeks time may be granted, my lord.
Be released by the next returnable date.
My lord.
My lord, I have not heard, my lord, because of the sound problem. Whether lordship has directed me to stay in Sibsagar or directed me to join in Dibrugarh.
Check the order. We have passed an order. You have check it. Get a certified copy today. You check it.
My lord, my lord.
We'll just come back in 5
My
minutes.
lord. I'm obliged, my lord.
May it please your lordship. My lord, kindly see last order, service for respond number 3 and 4 are awaited.
You want to take fresh steps or?
No, my lord.
My lord,
he's appearing. My lord, I think he's appearing.
I am appealing for
Three and
respond number 2, my lord.
3 and 4.
Respond number 4, my lord, I'm for all the response, my lord, because I've While the Ukalatnama today for respondent number 4 is signed by him. My lord, as per instruction, my lord.
No, are you also appearing for respondent number 3?
My lord.
No, only
But
for
only 4. He signed it, but he advised me to appear before this court for all the response. As
I have
per
not
instruction,
understood you. Are you appearing for all respondents or only for
4 miles.
only for 4? Not for all.
Not for all, but other officers is out of in other places, my lord.
Heard,
But
MS Bora and Mr. A.K. Dotto, Learned CGC, Learned Council, who represents respondent 1, 2, and 4. Office note reflects, office note dated 10/11/25 reflects that Sir AD card nor answer notice was returned in respect of respondent 3 and 4. Stop. Since Mr. Dotto represents respondent 4, notice is served. The notice is complete as regards service of notice in respect of respondent 1, 2, and 4. Steps on respondent number 3. Fresh steps on respondent 3 by registered post within 1 week from list after return of a bill.
well, process is going on, my lord, as per instruction, my lord. Process is going on. And please,
Have you filed your affidavits?
no, my lord, we have
File-
received instruction.
You filed your affidavit. Bring it on record.
So once-
Respondents will complete their instructions and file necessary affidavit. In the meantime. 21.
Same, my lord.
Same order.
Right.
Same respondents.
Respond.
Right. Okay. Huh?
Attach 22 to 24.
Your lordship may pass about the matter for time being. Mr. D. Nath is on legs in court number 18. So sometime, your lordship.
All right, time being. Some review petition.
My lordship may kindly peruse this order.
So this is the review petition.
Review petition.
Review petition.
Review petition.
Pending.
Now, my lord, what has happened here, my lord?
Hmm.
Before the writ proceedings, when the matter was disposed, it was disposed, my lord, at the motion stage itself thereafter. Now, my lord, affidavits were not exchanged. Concessions were given by the state councils that the petitioner's case is covered by earlier, my lord, by a particular OM, as well as covered by, my lord, earlier orders passed by this honorable court. Now, my lord, it attained, my lord, finality in that manner, my lord, and then it was sought to be complied. When it was sought to be complied, my lord, everything was done. Finance department was not arrayed as a party respondent in the writ proceeding. Now, finance has raised serious objections, stating, my lord, that this could not happen. This order is required to be reviewed. Now, under that circumstances, on the advice of finance department, as well as taking opinion.
You are filing, this review is pending.
Pending, my
It's
lord, that
fixed on 17.
17, after,
Right, so we'll defer it.
my lord. My lord, there is no willful and deliberate violation, because, my lord, we
That-
have done everything on
That
our
will
part.
be subject to outcome of what review orders. are.
My lord, my lord, my lord.
It is submitted that in the review petition 1790 of 2025
My
is
lord.
fixed on 17/11. And seeking review of which order is it?
My lord, here, my lord, the order is
The dated 26/9/2022.
Page number. Review of.
Page number 9.
dated
Lordship.
26/9/2022 passed in WPC 4932 of 2020. The willful and deliberate violation of the directions contained in which order not being complied with, the present contempt petition has been filed.
Now, Lordship, the
Now,
Finance
since the
Department.
review petition is fixed for further hearing on 17,
11. After 17, any week, my lord, that is what the order says.
2025.
My lord.
Let this petition, contempt petition, be listed for weeks there.
So obliged, my lord.
Please, your lordship. Lordship, on the last occasion, my lord, on the order dated 27/8/2025.
Yes, Mr.
Lordship.
Solia.
Yes, Lordship, here I have a speaking order that has been issued by the Lordship, Principal Chief Conservator of Forest, as per compliance, Lordship here. So I'll just place a speaking order. So nobody is appearing for the Forest Department, Lordship.
For the one, Mr. Gogol, and the information appear.
What is the effect of this order?
Lordship, here, Lordship, the principal, he has written that with,
What is the name of the petitioner?
Arjun Singh.
Arjun Singh.
Now, Lordship, here, they have only stated that regarding non-payment of salary, basic issue is that he was working from a period somewhere from 2015 July to 12th of December of 2016, his salary has not been paid. So he had filed a representation. Lordship had directed to consider the representation and dispose of the same. Now, pursuant to your Lordship's order, Lordship, this speaking order has been passed by the Principal Chief Conservator of
This is hardly
Forest.
a speaking order. The speaking order is to forward the papers.
Yes, Lordship, that,
Yeah.
that,
What kind of a speaking order is this? Who has passed it?
the Principal Chief Conservator of Forest. Principal Chief Conservator of Forest and Head of Forest. Now they were supposed to submit a proposal regarding the petitioner's case to the government. That is the, Lordship. This is an update which we have received. Lordship. Lordship, I have another letter that has been written by the same officer to the Special Chief Secretary Forest to the government of Assam. Now, but what action they have taken pursuant to this letter, Lordship?
This is not a very legible copy. Do you have a more? legible
Lordship, this
copy
is
available?
the most legible copy I have. Lordship. The other one is.
We need to retain it in record.
Yes, Lordship, here, but this order is not effective, Lordship, because they have only said that let the government take a decision. And then there's a letter, Lordship, dated 10th of September 2025, written by, regarding the said contempt, Lordship.
What was the direction so far as the?
To consider the representation for payment of arrear of salary, Lordship, for the period of 2015, July 2015
No,
to.
the direction was to dispose of.
Yes, Lordship. So now they've passed the speaking
And
order.
pass appropriate orders. So that has been disposed of.
Representation has not been disposed.
So that is the speaking order.
This is the order.
Yes.
I can provide him a copy of
You
this.
give him a copy. By order dated 30/11/2023 passed in WPC 6568 of 2023. The writ petition stood disposed of, directing with the following directions. Very quickly. Page number 13. In the last page. Since this order was not complied with, the contempt petition has been filed. Today when the matter is called up, Mr. H. Aliha representing the Forest.
No, Lordship, I'm for the finance. Lordship, respondent number 2.
Respondent number 2 has placed before the court a speaking order dated 4/7/2024, passed by PCCF and HOFF Assam. So the after considering the matter in its entirety, the PCCF had disposed of the representation with the following order. It will expect voting of order part 2. Stop. The said order has also been forwarded to the Special Chief Secretary Forest, Government of Assam Environment, Forest and Climate Change Department. Stop. By the order dated 4/7/2024, it is seen that the PCCF, after consideration of the entire facts, ordered that the observations made in the said order be forwarded to the Environment and Forest Department, Government of Assam, for a suitable decision and further orders for payment of salary to the writ petitioner from 23/7/2015 to 18/12/2016 in terms of the order dated 30/11/2023, passed in WPC 6568 of 2023. Mr. Chaliha submits that the matter is now under consideration in the state government for taking necessary steps to implement the decision of the court as well as the order passed by the PCCF. The writ petition, being WPC 6568 of 2023, came to be disposed of with this direction that the PCCF will expeditiously dispose of your representation dated 5/11/2022 and pass appropriate orders. A similar decision is also issued to the respondent number 8, namely the Commissioner and Secretary, Government of Assam, Finance Department. What orders have you passed?
No, Lordship, here only the area salary that has to be assessed by the Forest Department, Lordship. Area salary, they have their own budget, Lordship. If there's some shortfall and if they are in agreement with the period, Lordship.
The Learned Standing Council therefore submits that insofar as the direction to PCCF is concerned, that has been complied with by, as the representation has been disposed of by order dated 4/7/2024. So, however, the Finance Department would be required to
Environment Department, Lordship.
Respondent 8,
Lordship,
the earlier recommendation.
there was a direction to consider here we do not have that much of a role of this. The speaking order has already been passed.
The council submits that the respondent 8, namely the Finance Department, role in consideration for in passing any effective orders will come only upon the relevant proposals being issued in terms of the order passed by the PCCF dated so and so. Under such circumstances, since the directions contained in the order dated so and so, passed in WPC so and so, since been complied with by the present respondent number 1. And no respondent number 1. This court is of the view that the quantum petition at this stage can be closed with a further direction to the finance department to
Special Chief,
expeditiously,
Special Chief Secretary and Finance Department, Lordship.
special chief secretary of the finance department to expeditiously sanction and pass appropriate orders on any such proposals as may be received from the administrative department in respect of the claims of various salary of the writ petition.
Lordship, here, Special Chief Secretary to Governor of Environment and Forest Department, Lordship. That they are the ones who will take the call, Lordship.
Who is respondent to?
Lordship, respondent number 2 is Commissioner and Secretary Finance Department. But regarding arrear salary, we do not have the government in the Environment and Forest Department. They have to take they have to verify. They are the employer.
Respondent to, and who is that? Additional chief secretary?
Special Chief Secretary to,
Special chief secretary, forest.
yes, Environment and Forest Department, Lordship.
Environment and Forest and Climate Change Department will take all steps to sanction such claims for area salary as have been found payable to the contemplation.
Deeply on that.
Yes.
Timing items 22 to 24.
Yes.
But
Is
Lordship
that
has
order
direct.
you want a review of?
Lordship.
Which order?
Well, that physically handicapped persons, that
Page number.
page, Lordship, it starts from page 104 operative part. Starts from 91, operative part is at 108 million.
You want a review of what? Which order? Why you want a review?
At that time, some documents could not be produced, and subsequently, here, the Social Welfare Department did, and Social Welfare Department issued an advertisement for filling up more 860 numbers of grade 3 and grade 4 posts. Petitioners are grade 4, and social the SLPRB, SLPRB was entrusted to conduct the examination, interview, and accordingly, they adopted the procedure of digital Viva. And the 7 districts were already, they have taken the digital Viva mode. And subsequently, it was cancelled. And the process was thereafter continued by the Guwahati University. And Guwahati University cancelled the earlier all process. And
They wanted to go afresh.
Yes. And we have on the basis of this office memorandum, the page 110 and 111. 111 is the office memorandum issued by the state government, whereby the interviews for the recruitment of grade 3 and grade 4, where personality assessment is not the absolute requirement, will be discontinued. And Lordship wanted to know earlier, whether these two office memorandum are still holding the field. And also we have contended that cabinet decisions was there regarding adopting the process of digital Viva. Lordship wanted to know basically these two facts. And subsequently, if your Lordships see the page 37 of the review petition, which is the advertisement. Page 37 in advertisement clause 14, they have stated the paragraph 3, 4, 6, 7 and 12 of
of a my lord office memorandum issued by the Ministry of Social Justice and Empowerment Government of India will be followed. This is the my lord the office memorandum I have found, my lord. As per paragraph 7 of this office memorandum also, my lord. To conduct the my lord, interviews for the
Where
persons.
is the error?
Error, my lord, earlier occasion, my learned senior, my lord, Mr. Ken Chaudhary was leading me, lordship. Already, because, my lord, some documents could not be brought at that time, my lord.
You file an appeal, why you want a review?
In spite of due diligence, my lord, those facts could not be brought before your
All
lordship.
right, Mr. Nath, what do you have to say?
Lordship has directed me to obtain the instruction as regard two documents. If Lordship kindly takes up order dated 35/2025 of this writ petition. These are connected cases. Kindly see 35/2025 order. That is basically their grievance. It's a two documents. All of the one is the ultimately they have annexed in the writ petition itself the last page. But I'm reading the order. 35/25. This is their grievance basically. The writ petition has been filed putting to challenge the minutes of the meeting held on 8/2/2021, whereby the decision was taken to cancel the digital viva conducted and to hold the interview afresh for the purpose of selection and appointment to the post of grade 4 reserved for the persons with physical disability in different departments under the government of Assam. The petitioners being desirous to participate in the selection process and having presented themselves before the authorities, the decision for cancellation of digital viva was taken after the selection commenced, which is contrary to the procedure and rules prescribed for conducting selection and appointment of the persons for post of grade 4. Now, they have said, my lord, in the review petition, while filing the review petition, they said that the digital viva has been adopted by the cabinet by in a decision taken in the cabinet meeting held on 9/10/2018. So that extract of the minute, my lord, I was directed to bring, my lord. And secondly, my lord, I was directed to obtain the instruction as to whether the communication of 25/5/2016 is still holding the field or not. My lord, the extract I have got, the cabinet extract I have got, my lord, there is nothing, my lord, that there is no mention as regard the digital viva here.
As regard?
Digital viva. They said that the digital viva, they are relying on digital viva, that digital viva is to be there and that is a established procedure. They want to rely on that. That is the minor.
Then where is the other, some other document you?
In fact, that particular document, 25/5/2016, is a part of the writ petition. The last page, my learned friend has read, Malab.
Not the review petition.
Review petition.
Review petition.
In the review petition itself.
Page number?
The
111 last page.
Last page, 111. This is a letter by the Secretary of the Personnel Department to all the Additional Chief Secretary. And it says, there, my friend has read second paragraph. In this respect, the Honorable Chief Minister of Assam has directed that the system of holding interview for recruitment of such grade 3 and grade 4 posts, where personality assessment is not an absolute requirement, will be discontinued with immediate effect. The last paragraph is important. You are therefore requested to examine the matter in respect of all establishment under your administrative control and make necessary amendments to the prescribed respective service rules, executive instructions wherever required to discontinue the process of interview for recruitment of grade 3 and grade 4 post. So look, this is a letter written to all the departments. I have received the same instruction. It said that it is a communication from the personnel department to all the departments. Wherever they find, they are to examine the matter, and wherever they find under their administrative control that the
interview is not required, they will make necessary amendment, but nothing has been done.
And what is the Guwahati University has to say?
Guwahati University, in fact, Lordship, they said that we have already completed and there is an order in the petition that they have nothing to say in the matter further. If Lordship kindly comes to paragraph 22 of the review petition, my lord, that is basically their case. Look, I am holding on, I am having only one copy of the, kindly take up review petition 60 of 2021. I don't have all the three cases, my lord.
Page number?
Page number 36 of the review petition. What my lord, they are projecting now, kindly see para 22, that the review petitioners respectfully state that there is an order by order numbers so and so dated 25/5/2016. That is the last or letter, my lord, which I have read just now, issued by the government of Assam to the additional chief secretary, principal secretary, commissioner secretary, secretary of all the departments under the government of Assam with a direction for discontinuation of interview and recruitment of junior level post. In the said order, it was directed, referring to a direction of the Honorable Chief Minister of Assam, that system of holding of interview for recruitment of such grade 3 and grade 4 post where personality assessment is not an absolute requirement will be discontinued with immediate effect. It is also directed to examine the matter in respect of all establishment under their administrative control and make necessary amendments to the respective service rules, executive instructions wherever required to discontinue the process of interview for recruitment of grade 3 and grade 4 post. It is pertinent to mention herein that the central government also filed office memorandum number so and so dated office memorandum dated 13/4/2017, referring to its earlier office memorandum number so and so dated 9/10/2015, clarified that the decision of discontinuation of interview in junior level post in the government of India is applicable to recruitment of all post group up to group B non-gazetted irrespective of mode of appointment, promotion, deputation, direct recruitment, etc. Then they said, my lord, basically they said that the interview should not be as, my lord, we should not, the authority should not insist on the interview because the instruction of the government is there and the minutes of the cabinet is there to the effect of digital viva. On these both counts, they said that they could not bring these two things before the Honorable Court at the time of passing the order dated 8/3/2021. Therefore, they have prayed for review.
Is there anything about digital viva here in the cabinet?
No, my lord. I have placed the minutes. They have only said that for recruitment, one should go to the state level police recruitment board. This process, my lord, was initially initiated by the state level police recruitment board. Subsequently, my lord, because of some illegalities, it was given to the Guwahati University. Second, my lord, the state level police recruitment board will conduct a common test for grade 3 and common test for grade 4 as far as possible. There's nothing for digital viva.
All right, we'll pass orders next week.
Fine.
But counsel for parties. Sir, Konita appears for the NK Konita for the review petition, Mr. D. Nath appears for the state. Mr. Nath was placed before the court. A copy of the extract of the minutes of the cabinet meeting held on 9/10/2018. And submits that there is no decision taken by the cabinet that digital viva will be resorted to in the recruitment for grade 3 and grade 4 posts by the state, conducted by the state level police recruitment board. Stop. He further submits, if he is further placed before the court, copy of the OM dated 26th of February 2013. Issued by the Government of India, Ministry of Empowerment. Laying down comprehensive guidelines for conducting examination for persons with disabilities as recommended by the CCPD. There is no digital viva here.
Second OM, my lord, I am not aware of because he has submitted. My friend has submitted.
Okay, another OM.
The Union of
26th of February.
The-
You have given 26th of February.
25th of February 2016. That I have.
No. Who is given this 26th of February 2013?
Yes, my lord. I have submitted. He has.
You have submitted.
Yes,
my lord, paragraph 7, my lord.
Oh.
Paragraph 7. It is stated that persons with disabilities should be given the option of choosing the mode for taking the examinations, that is in Braille or in computer or in large print. So these were not followed, my lord. Only
This is not even your ground. Your ground is digital viva.
no, well, kindly see advertisement, lordship. Kindly see the advertisement. Advertisement, page 57 of the
All right,
60.
we will take it up next week.
Well,
You are seeking a review. This is not an appeal.
Yes,
so, my lord, this
This is a review.
yes,
So you have to point out the glaring error which has occurred.
this is one of the, my lord, because advertisement quoted that such and such paragraph will be followed.
All right. On yes.
The petitioner, he was promoted to the post of junior assistant. Plus, he will come to page 16, man. This is the minutes of the selection committee. There was 11 posts, my lord. 2 posts, my lord, attached to central, my lord, monitoring cell. 18 recruited through direct recruitment, and 1 the petitioner that was promoted from grade 4 to junior assistant. Subsequently, my lord, that was forwarded, and ultimately, my lord, page 19 is the promotion order, man, of the petitioner. Subsequently, he joined at page 26. And page 27, he was entrusted duty, my lord. Bhargav Hazarika, CL number 2, junior assistant, issue and dispatch of official letters, my lord. And his, my lord, page 23 is the part of the service book. It was incorporated, recorded in the service book. Now, my lord, the office of the executive chief engineer water resource is shown his post as a vacant, my lordship, and placed the CL number 5 Anupam Bora in his post, my lord, where he is serving as a junior assistant, my lord. May I read the, my lord? In the interest of public service and administrative exigency, and in response of their own request, the following junior assistant under Water Resource Department are hereby transferred temporarily and posted in the same capacity to the office shown, offices shown against their names against sanctioned vacant posts with effect from. So my post is where I've been promoted, and my promotion order till today existing, my lord, is not reviewed, recalled by any authority, my lord. My post is shown as vacant.
What is your name?
My name is not my name is Bhargav Bora. That my post is, I have been promoted to that post, my lord. And since 23, I have been posted and serving in that post, my lord. The Anupam Bora has been.
Your Bhargav Hazarika.
Bhargav Hazarika. And my promotion transfer is not there, but my post is shown as, my lord, vacant, my lord. And this Anupam Bora, on request, he has transferred to that post. Accordingly, my lord, executive engineer informed me that your post is shown as vacant, and so I have come before this court. And he,
No, you are promoted to the
Junior
vacant
assistant.
post of junior assistant.
And
And which establishment?
Water Resource Department, my lord, under the establishment of, my lord, Executive Engineer, Jorhat Water Resource Division.
It does not reflect in your office order.
That is, my lord, at page 19, my lord. My promotion order.
You show us it is not reflected here. In which establishment you are promoted, it says you are hereby promoted.
My lord, because my lord, in the, my lord, page 16 order, here it was, a meeting was held on 11/5/2022, page 16, at the office chamber of the Executive Engineer Jorhat Water Resource Division, Jorhat, under the chairmanship of Executive Engineer Jorhat Water Resource Division, Jorhat, was attended by all the members. The chairman welcomed the members present and intended the discussion regarding the selection of service Sokidar for filling up the permanent vacant post of junior assistant under this division. Accordingly, my name was suggested. So under that division, man. And subsequently, man, page 19 is the promotion order that promoted, and I have been interested and engaged, my lord, page 21, Bhargav Hazarika junior assistant.
So under the office of the executive engineer, Jorhat Water Resource.
Jorhat Water Resource Division.
There's only one post.
No, there was 11 posts earlier, junior assistant, 2 posts attached with the central monitoring committee, so 9 remaining. Out of the 9 vacant posts, 8 posts were recruited through, my lord, direct recruitment, and 1 post, my lord, through promotion from grade 4 to grade 3, and that post is holding by the petitioner.
No.
And now that post is shown as vacant.
How do you say that it is shown as vacant?
My lord, from the transfer order, it can be, my lord, understood, my lord.
So
Page 24 order.
Transfer order.
Against the sanctioned vacant post. But in 2023, that is filled up by me, madam. Promoted, but it filled up through promotion by me. But in the office of the executive engineer, it is shown as a vacant post.
According to you, there is no other vacant post.
No other vacant post. All are recruited, 8 recruited through direct recruitment, 2 attached to
Any person transferred from.
Yes,
this-
my lord.
this post?
5, CL number 5, Anupam Bora, Office of the Executive Engineer, Katigora Water Resource Division. The name of place of posting, Executive Engineer, Jorhat Water Resource Division. That is, he is coming against my post. And in that order, I have not been placed in any other.
Yes, Mr. Das.
Lordship, the petitioner was joined in service in 13/12/2018, page 14, which he has annexed. As per Lordship service rule, this Assam Ministerial District Establishment Service Rule 1967, Lordship, from lower division assistant, means for promotion to the post of lower division assistant, Lordship, 7 years, this 7 years of service is required. So his promotion means his service, he will complete 7 years in the month of December 2025. But regarding this one, Lordship, the letter, that service book which the petitioner has annexed in page 23, he has mentioned one letter, Lordship, that the Deputy Chief Engineer Department letter number so and so. In that letter, Lordship, Deputy Chief Engineer has strictly refused, Lordship. This is the copy which I have received from the department.
I have enacted order, my lord, page 18.
Still petitioner is drawing the salary of Chokidar only.
No, what is the effect of this order?
That executive engineer has given promotion of his own without any approval. That the deputy chief engineer has straightly refused. That letter reflects, Lordship.
Which page 18 letter?
This is one in page number 18 only.
Page number 18, same letter.
Page 23.
With reference to the above,
Yes,
I
Lordship.
am to return here with the proposal in respect of promotion from Sokidar to the post of junior
Yes, Lordship.
assistant, and state that
Same
the appointing
letter.
authority is the competent authority. So appointing authority was executive engineer, so he forwarded the same to the appointing authority. Authority,
has not
in
been
competent
approved.
authority to take necessary step for promotion from Sokidar the higher.
And if
cadre.
Lordship may peruse the service book, means this service rule, Lordship. Service rule, it's clearly written that 8 years of continuous service, Lordship. I have marked that one, Lordship.
I don't.
From Chokidar
Oh,
to
my lord, rightly or wrongly, he was promoted and he is holding that post, my lord. His promotion order is not recalled by any authority and not reviewed. Not reviewed and not cancelled, my lord. So so long,
but
my
he
lord,
is not doing any salary.
the promotion order is existing, my lord.
But his promotion is there, there's an official order. It has
Lordship,
been
That
entered.
is not recalled.
That order has been, means now only the authority came to know about this order
So you
because
take whatever steps, but as on date, so he is there in the post. Can he be thrown out?
no, he will not be thrown out. Lordship, he will be promoted to that post in the month of December, Lordship,
Whatever it may be, but
as
there
per
is a-
service rule, Lordship.
see, if you say the executive engineer is not authorized, then you'll have to take action against the officer concerned and recall the orders or cancel these orders. Have you taken any steps to that effect? The
Lordship,
promotion
today-
order does not reflect that his promotion will take effect from December. It does
Lordship.
not reflect.
Ah.
If therefore he goes and he joins.
Ah.
And he's been assigned some work, his service book is also there. So how can you now issue this order and directing another person to go and join in his place without recalling that promotion order?
Then I have to take the instructions, Lordship,
your-
whether order has been recalled or not.
Heard Mr. J.C. Goel, other counsel for the petitioner, as well as Mr. R.M. Das appearing for the Water Resources Department, representing respondents 1, 2, 3, and 4. Stop. Petitioner was serving as a grade 4 office chowkidar in the establishment of the office of the executive engineer Jorhat, Water Resource Division Jorhat, under Simsagar Water Resource Circle, by appointment order dated 1/2/2018. Stop. The petitioner subsequently came to be promoted to the post of a junior assistant under the same establishment. Stop. This was in terms of recommendation by the selection committee for promotion of candidates from Chowkidar. Stop. The minutes of the meeting dated 11/5/2022 had shortlisted and recommended the petitioner for being promoted to the post of junior assistant on fulfillment of the criteria. Stop. Subsequent thereto, the promotion orders were issued by the order dated 2/5/2023, whereby the petitioner was promoted with effect from the date of joining in the vacant post of junior assistant under the establishment of executive engineer Jorhat, Water Resource Division, Jorhat. Petitioner also also submitted a joining report on the same day, which is 2nd of May, 2023. So thereupon, the petitioner was assigned his work and was engaged in his duty, was entrusted with his duty of issue and dispatch of official letters. So, the promotion of the writ petitioner was also recorded in his service book, an extract of which he has been produced before the court. So, while he was serving in his office by order dated 11 November 2025, junior assistants mentioned in the same order under the Water Resources Department were transferred temporarily and posted in the same capacity in the offices which are shown against their names in the same order. Stop. At serial number 5, one Sri Anupam Bora, i.e. respondent 4.
Respondent 5, man.
No, 5 was shown to be transferred from the office of executive engineer Katigora, Water Resources Division, to executive engineer Jorhat, Water Resources Division. So, Whereas the learned counsel for the petitioner submits that as per information available to the petitioner, out of the total cadre strength of 11 posts of junior assistant under the Jorhat Water Resources Division, two posts have been earmarked for,
Already, my lord, attached with central monitoring cell.
have been attached with the central monitoring cell.
8
And 8
requested for the
posts have been filled up by way of direct recruitment. Stop. Only one post was filled up by promotion, which has been filled up by the present writ petitioner. Stop. The counsel for the petitioner submits that the writ petitioner has serious apprehension that has expressed serious apprehension that the person at cell number 5, namely respondent number 5, has been transferred to be posted in the post held by the petitioner, which has been shown to be vacant by the impugned order dated 11 November 2025. So this therefore could not have been done in view of the office order dated 2/5/2023, whereby the writ petitioner was promoted to the said post of junior assistant under the said establishment, and in which post he has joined on 2nd of May 2023 by submitting a joining letter, and has since been working in the said post. So he therefore submits that the impugned order, insofar as the private respondent is concerned, should be interfered with, and the post in which the petitioner is serving should not be shown to be a vacant post available for being filled up by way of transfer or direct. Well, Mr. R.M. Das, standing counsel, appearing on behalf of the respondents 1, 2, 3, 4, submits that the petitioner does not fulfill the requirement of service, requirement of rendering service of how many years?
8 years.
8 years, as is reflected in the rules governing the services of the writ petitioner. Stop. He will complete 8 years only in December 2025.
2020.
And therefore, as on date, he was not eligible. However, insofar as on a pointed query by the court as to whether the promotion order dated 2/5/2023, by which the writ petitioner was promoted to the vacant post of junior assistant, was recalled or kept in abeyance by the competent authority, Mr. Das submits he has no instructions on this. He prays for 2 weeks.
1 week.
2 weeks time to complete his instructions. So, and considering the prayers made, let this matter be listed again after 1 week.
And in the meantime, my lord,
On 24th.
24th.
24th of November. Enabling the learned standing counsel Water Resources Department to complete his instructions. Stop till the next returnable date. The impugned order dated 11 November 2025, insofar as serial number 5, namely the private respondent is concerned, shall not be given effect to without leave of the court. So, the learned counsel for the petitioner will ensure service of extra copies, sufficient extra copies to Mr. Das during the course of the day, as also an extra copy All right. During the course of the day, that is top below. Let this matter be listed as directed on 24th.
High level.
For orders, item 27.
Order
Lordship,
supplied.
in this case, Lordship, instruction received, Lordship. Lordship,
Order supplied.
Lordship, not Lordship, because the criminal case is pending against the petitioner, Lordship. Therefore, the Lordship, the respondent could not issue the appointment letters. This is the instructions.
What is the direction here?
My lord,
Page number 9.
lordship. 9, 11 and 10. Last paragraph. To dispose of one representation.
So have you disposed of the writ petition as the representation?
That was not communicated to us, no?
Representation, has it been disposed of?
This note.
Respondent number 4, who's respondent 4?
Deputy Commissioner, District Commissioner.
Deputy Commissioner. Why can't you tell us, is it disposed of or not?
Lordship, it is not there, Lordship.
It is not there, you get your instructions. Mr.
DJ Boro, Lordship, on behalf of J.K. Goswami.
DJ Boro appearing on behalf of Mr. J.K. Goswami, praised for another week's time to complete his instructions as to whether the directions contained in the order dated 28/6/2023 passed in WPC 3808 of 2023 has been complied with. By the respondent, sole respondent. So let these instructions be placed before the court on 24th of November. Mr. H.A. Ahmed appears for the writ petition.
Obliged. 29.
My lord, my senior is in 418 in fixed matter. I'm requesting for a passover for the timing.
Lordship, in this matter, we have filed a affidavit, Lordship. Here, basically, the petitioner is claiming minimum of the pay scale. And PWD had submitted that they had sent a proposal, Lordship. To that effect, we have filed the affidavit stating that the proposal was received in the year 2022-23. So that proposal has lost its, it has been expired, Lordship. So, and the government has recently asked all the departments to forward the name of the candidates who are eligible for minimum of the pay scale. So whether they have sent the name of the petitioner recently, Lordship, that instruction is not there, Lordship.
Maybe pass it over, you get the instructions from your senior. We'll take it up at the end of the list. Yes.
Lordship. Item 30.
May I please, your lordship?
Yes, yes.
Lordship, in this petition, I would just like to press on the dismissal of service was laid down on the basis of merely 3 allegations, your lordship, and for which we can, lordship can, I would like to direct.
What are you challenging? What are you challenging?
Lordship order.
I know which order, dismissal. You're dismissed from service.
Dismissal, lordship.
Dismissed from service.
Dismissed from service, lordship.
Did you file an appeal?
Yes, lordship.
What was the appellate order?
Just rejected, your lordship.
Rejected.
Yes, lordship.
Where is the order of dismissal? Page number?
Lordship, page number 43, lordship.
Do you have the inquiry report?
Yes, your lordship. Page number 39, your lordship, in regard to the statement and inquiry.
Yes, respondents.
Lordship, I think a record is required because certain allegations has been,
All right, heard counsel for parties.
Lordship, one submission. Lordship, merely this incident is about 2018, and in the entire case put against me, and there is no CCTV footage available in the entire allegations along with the 3 allegations, your lordship. And this is a case of Sadgaon police station where CCTV is available, your lordship, in every room, as per what I know. But my allegations are labeled against me where the concerned with the investigating room, whereas in every corner CCTV footages, CCTV cameras are available, your lordship. So I'd like to request about the availability of CCTV footage, your lordship.
CCTV footage is there.
Yeah, CCTV cameras
Were there.
cameras are available, your lordship. And lordship, whenever a woman is goes to the police station, it's merely a simple category or a process that a woman officer follows her whenever she enters in officer's room. This is highly phenomenal, lordship, but everything is missing in the entire case, lordship.
Lordship, kindly peruse the charges, Lordship. This is only gross misconduct and dereliction of duties. So these things, CCTV footage and all these things are not required. This may be required for the criminal proceedings, Lordship.
No, but the allegation is very specific.
Yes, Lordship, that's why. That's why record will be required,
Why not,
Lordship.
Lordship?
All right, we'll examine.
Yes, Lordship.
You are not filing a rejoinder affidavit. There is an affidavit in opposition filed.
No, no, Lordship, this is an inadvertent mistake, Lordship. It was there. We'll be filing it within 10 days, Lordship.
No, I think some affidavit is there.
Affidavit, respondents affidavit, Lordship.
Affidavit has been filed
Yes,
by
Lordship.
respondent 7.
Yes, Lordship.
Is it sufficient for all the other respondents or?
Yes, subsequently, he was transferred to Nalbari Lordship. But from the concerned authority is required, Lordship.
Hmm? Who is the
As per
respondent?
number 7 was the disciplinary authority, Lordship.
7 is the disciplinary authority.
Yes, Lordship, because when at the time of commission of offense, Lordship, he was posted in Nunmati, Lordship, which was under the this Guwahati police district, Lordship, but later on he was transferred to Nalbari, Lordship.
Now, are you filing any further affidavit?
Lordship, that's why I'll just examine, Lordship, whether this is required or not. Anyway, Lordship, we have to wait for the record, Lord.
Counsel for the parties have been heard. The petitioner is before the court putting a challenge to the order of dismissal from service, as well as the order passed by the appellate court confirming the order of dismissal from service by the disciplinary authority. Respondent number 7, namely the superintendent of police Nalbari, who was the relevant point in time, the disciplinary authority has filed an affidavit. So, no rejoinder has been filed to the said affidavit by the petitioner. Stop. Considering the fact that the matter pertains to dismissal from service, pursuant to departmental proceedings undertaken, are initiated against the petitioner, but let the relevant records pertaining to the department proceedings undertaken, including the proceedings of such departmental proceedings, be placed before the court within the next 3 weeks. The counsel for the respondent is also permitted liberty to the counsel for the state counsel of the respondent is also permitted liberty to file additional affidavits in opposition if so advised. List again after 3 weeks.
Lordship, the CCTV footage records is available.
Huh?
CCTV footage records. Yes.
We'll see first. Let us see the records. If required, we will see.
Published, Lordship.
Lordship, here I placed some time to file my affidavit. Lordship, here I received the instruction networking not filed.
Have you complied?
Yes, sir, Lordship.
You have
As per-
complied?
Yes, Lord.
Yes, Mr. Pathak.
My lord,
Yes,
there
per
seems
my-
to be a dispute on that, my lord. Dispute is of this nature, my lord. What lordship has directed is that this particular person, my lord, he had suffered the injury attributable to duty. And my promotion was initially not considered because I am not 100% physically fit. Lordship had held that since it is a matter attributable to duty, your promotion is to be considered and you are therefore to be put up in the next DPC. Now they say we have put you up in the next DPC, but again they have rejected me on the ground that I am physically unfit. So bringing me back to square one, my lord.
You want to file an affidavit?
Lordship.
Bring it on record.
My lord.
Lordship.
Mr. B. Patel for the petitioner, Mr. S. S. Roy, learned counsel for respondent. Mr. Roy submits that you would like to file an affidavit bringing on record the instructions received. Is for 2 weeks.
3 weeks, Lordship.
3 weeks time. 3 weeks time. It's accordingly after 3 weeks.
Lordship, here, Lordship, I inadvertently I have failed to take steps, Lordship. I will take within Monday, Lordship, I will take it. Inadvertently, I failed. Review petition.
Counsel for the review petitioner is permitted to take steps within 1 week. List thereafter. Steps by registered post. Sorry, speed post. Speed post within 1 week. Be listed thereafter after 3 weeks.
Lordship.
Obliged.
33. You contempt your Lordship, there was a direction passed by the Honorable Court. However, for a long period of time.
What is that order? Which order?
Your Lordship, page number 30 of the application. Lordship is the relevant portion.
The Lordship may kindly peruse the last order of this Honorable Court.
30.
That is, the petitioner is being directed to reinstated in the service and however taking into consideration the nature of charges and the respondent authority, if so advised, may proceed with the stage of issuing of the second support notice. And your Lordship, that is on the day of filing of the writ petition, already he has attained the age of superannuation. So basically, it cannot be implemented, your Lordship. That is, I have filed an affidavit.
No, you are saying that on a day when the order was passed,
Yes.
it superannuated.
Yes, your Lord.
Did you file a review?
No, your Lordship.
Then? Because they brought it to the notice of the court that on a day when this order was passed, he's already superannuated. Therefore, it can't be implemented.
That is only when we have taken that regarding the implementation of the order, then we come to know. But by the time it is 1 month has been elapsed. And by the time we have also filed an appeal before the appellate.
There's no limitation for review as far as I understand.
I'll do file your Lordship.
We are not advising you, but it's up to you.
In this case, there was a direction that the respondent, the contemners may appear personally before this Honorable Court. The contemners may appear personally before this Honorable Court. There was a direction passed, your Lordship, on the.
On 4/11/2025, your Lordship.
4/11.
Yes, your Lord.
22/10
And prior to that, on 10/11.
On 22/10/2025, there was an order, your Lordship.
22/10/2025.
Thereafter, your Lordship, we have filed one miss case. And on 4/11, we have been directed either to implement the order, comply the order, or to remain present personally before the Honorable.
Yeah, we are not here to give you legal advice. You
No,
are
no.
the legal advisor of the respondents.
Yes, your Lordship. That
You
is why I have-
decide what is to be done. If there's an order of the court which needs to be complied, you have to explain why it is not complied with.
Exactly.
If you want to say that it is not capable of being complied, you have remedies. What are you doing?
Your Lordship, I have filed appeal and
It's been a year, your Lordship.
if appeal is being filed, your Lordship, review,
What is the stage of the appeal?
your Lordship. We have just filed, your Lordship.
Your Lordship may kindly peruse this judgment of the Honorable.
The purpose of the court giving you time to comply with orders is only to ensure that there is no taking into account some difficulties that may come across. The purpose of granting you enlargement of time is not to file an appeal or a review.
No, your Lordship,
You are to, once an order is passed, you are to comply.
Exactly, your Lordship.
Unless you show us that it cannot be complied with. You show
Yes,
us
your
when you
Lordship,
retire.
since he is being superannuated.
Where is that order of superannuation? Where is the order? When did you
Your
superannuate?
Lordship, Annexure 1, page number 44, your Lordship.
44.
Yes, your Lordship. It is a part of the writ petition that has been filed in the writ petition, your Lordship itself.
understand that we are now taking up the contempt petition. Exactly. Which is contempt number 283.
Yes, your lordship.
In this proceeding, have you enclosed it?
Yes, your lordship. The relevant portion I have included.
Page number?
Page number 44, your lordship.
44.
That is para number U, I think, your lordship. Last three line, your lordship. That is the no reasonable person properly instructed in law could have passed such an order as has been done in the present case, where there is remaining only 1 month period of service of the petitioner from his retirement. And your lordship, the affidavit that has been filed in the page number 45, that is an age of 60 has been mentioned.
You said the man superannuated on the day the writ court passed an order.
Yes, his
You are
age of retirement has been crossed, your lordship.
No. Date of retirement crossed is a different issue. In your bank records, you will have to have some order to say that this man is released because he's superannuated. Have you passed any order?
No, your lordship. Order has not been passed because he has filed an writ petition in the month of August. And we have been dismissed from the service in the month of January 2018.
He is superannuated or dismissed? He was
He
initially
has been
dismissed.
dismissed in the month of
Then
January.
reinstated.
No, your lordship.
He was not reinstated.
Not reinstated, your lordship.
So
That is
what
why we
what
are
is this
challenging.
order?
Your lordship, may kindly. Where was the,
Page number 30, your lordship.
Directed to be reinstated in service.
Cannot be possible, your lordship, for us. Because there is no
We are
backages
trying
and
to
others.
understand the facts. He was an employee of the bank.
Yes,
There was some proceeding initiated.
yes,
And pursuant to the inquiry, he was dismissed.
yes, sir.
Then he came before the court.
Yes, sir.
Court interfered with this order.
Yes, sir.
Directed reinstatement.
Reinstated.
So this order was passed on,
That was passed on 26/9, your lordship.
it is true that he has.
24/9/2024.
24/9/2024.
24/9/2024.
So on that day, what was the position?
Your lordship, on that day, he was not in, he cannot be in the service, your lordship, because his age of retirement is 28 February 2018.
So you should have brought these things before the court.
Your lordship, your lordship, because the petitioner has itself has not stated, your lordship, before this.
Don't you have any records regarding your employees? When their date of entry, date of exit from the service? Every department will have that?
Yes, your lordship, but that we have only come to notice when we are going for the implementation.
On which date did you come to notice? Which date?
Yes, sir, only just 2 weeks before, your lordship.
2 weeks before.
Yes, your lordship, when that on the last occasion when we filed an interlocutory application, thereafter we have all of a sudden we have filed this affidavit, your lordship.
What interlocutory application you filed?
Yes, regarding your lordship, that what was happened when the day was fixed, in the early in the morning, I was present before your lordship. But thereafter, when the matter was called up for the second time, I was not there, your lordship. So the personal appearance was given. So that is why for exonerating them from personal appearance, I have filed an interlocutory application. And thereafter, this order is being passed, your lordship.
Which order?
That is 4/11/2025. That either I have to implement the order or be present personally, your lordship.
4/11.
Yes, your lordship.
Where is that 4/11 order?
In IA, your lordship. IA.
No, it's a 22/10/2025.
4/11/2020. After that order, I filed this affidavit, your lordship.
Yes.
That is why then thereafter we have filed this affidavit before your lordship. That it cannot be executed.
Now this, in view of this stand, it is a clear case of contempt.
Lordship, I am very sorry.
Have you seen your submission in this order 411? You have submitted before the court, some time may be granted to comply with the same. And now you come and file an affidavit saying that it cannot be complied with. You are giving an undertaking to court.
No, your lordship. Undertaking, I have been advised, your lordship.
Huh? No, do you have a copy of 411?
Yes, your lordship.
Yes.
That he has advised to the applicant to comply with the order of this honorable court, your lordship.
And see thereafter?
And thereafter, submission that the court is inclined to dispense with the personal appearance till 10/11, on which the compliance order has to be placed before this court or the personal appearance.
So where is the compliance order?
Your lordship, it cannot be executable, your
It
lordship.
cannot
that
be,
is-
you face contempt.
Your lordship
Where are your clients?
is in Calcutta, your lordship.
You call him, why have they not come? We issue warrant?
No, your lordship.
What do you think, they're playing with the court?
No, your lordship, that
Then?
is, during the submissions in the writ petition, that was
No,
not
no, no,
come
we
to the
don't know.
knowledge, your lordship.
We'll issue non-bailable warrant now.
No, your lordship. It's-
Who are the officers required to be present here?
I'm very sorry, your lordship.
You're sorry, it doesn't help. There's an order of the court, you have to comply. Or take recourse. Third, Mr. T. Deori, learned counsel for the petitioner, Mr. M. Sharma, learned counsel appearing for the UCO Bank. The contempt petitioner, the petitioner in the contempt case, for the approach this court by filing WPC 557/2018, assailing the charge sheet issued by the bank, the disciplinary proceedings initiated against the petitioner, the impugned, the inquiry report dated 25/9/2017, submitted by the inquiry officer, the order passed, order dated 1/1/2018, passed by the zonal manager and disciplinary authority, UCO Bank, by which a penalty of dismissal from service was imposed on the petitioner, as well as the order passed by the appellate court. Upon hearing matter in its entirety, a coordinate bench allowed the writ petition with the following directions: 22 onwards, 22 to 26, page number 29 and 30. Whereas since this order was not complied with, the present contempt petition has been filed. So, notices in the contempt petition was issued on 2/6/2025. So, on 22/10/2025, this court directed the respondent / contemnors to remain personally present before this court on the next date fixed. In view of this order being passed, an IA was filed, being IA Civil 3530/2025, seeking recall of the order or compliance or personal appearance of the petitioner. Stop. The said order, the said IA, came to be disposed of on 4/11/2025 with the following direction to extract this order. Stop. The matter was thereafter fixed on 10/11. Stop. On 10/11, the matter was further adjourned to 14/11/2025. Thereafter. Today, when the matter is called up, the counsel for the the respondent bank submits that the directions contained in the order dated 24/9/2024, whereby the petitioner was directed to be reinstated, cannot be complied with as the petitioner had already
Attained
attained the age of superannuation. Stop. This, the respondents have sought to point out by placing an extract, the placing a part of this is what a part of the appeal.
Writ petition.
Writ petition.
Writ petition. Is in the writ petition, because on the day of filing,
Part of the grounds are in the writ petition to submit that the petitioners, that the direction of the court cannot be implemented as the petitioner has already crossed the age of superannuation. So the further submission is that an appeal has been filed against the state order. However, what is the status of the appeal?
Your Lordship, it is in filing defections.
Not numbered,
Yes, only filing number has been given.
which is yet to be numbered. Stop. Where? Considering the submission made as well as pleadings available on record, prima facie it appears to the court that the respondents are not taking the adequate steps necessary for implementation of the directions contained in the judgment and order dated so and so passed in WPC. The judgment and order dated 24/9/24 passed in WPC 5574 of 2018. So the respondents, contemnors were directed to be present personally in court, which order came to be modified by granting them further time till 10/11/2025, on which date the compliance order was directed to be placed before the court, or they will have to remain personally present. Stop. Today, when the matter is called up, and on 10/11, further time was granted by to the respondents, as it was stated that an affidavit in opposition has been filed by the.
On that day, one officer was presenting. On that day, one officer was present before.
Don't know.
But your Lordship,
And the matter was directed to be listed on 14/11/2025. Stop. Although the counsel for the respondent submits that one of the respondents, which
Yes.
respondent?
this Samudip, that is respondent number 3.
Respondent number 3
This
was
the
present
journal manager at that.
personally in court, however. No such reference is found in the order dictated. So, the such circumstance and today, when the matter is called up, the counsel for the respondent submits that an appeal has been filed, which is yet to be numbered. Therefore, this court is of the view that the prima facie it appears to the court that the respondents have deliberately and willfully attempted to avoided from compliance of the directions contained in the order dated so and so, passed in WPC so and so. Accordingly, let notice issued under section so and so read with Guwahati High Court contempt of court rules in the format prescribed with all the respondents as to why the proceedings under the Contempt of Courts Act, as well as read with the rules so and so, will not be initiated against them. The respondents are granted 4 weeks' time to file their response pursuant to receipt of notices as directed to be issued by the registry by registered post. So let this matter be listed again on 9th of January, by which date the respondents, namely so-and-so, are directed to be personally present in court. If the respondents fail present themselves as directed by this court, then further consequential orders may be issued by the court, based accordingly.
Very grateful.
One for complete. But as per the service note, the service on respondent number 1 is not completed.
I have entered appearance for
Okay.
respondent number 2 though.
2 is the main implementing authority though.
Lordship, let the matter come after 2 weeks, Lordship. Let me take the latest instruction on latest position, Lordship.
Office report dated 10/11/25 reflects service on respondent 2. Respondent 1 is not complete. Stop Mr. B. Chaudhary, B. Chakraborty, learned CGC. A learned counsel appears for respondent number 1. Respondent number 2. The service is not complete on respondent number 1. Mr. Chakraborty appears for 2. Mr. Chakraborty submits that he prays for further time to complete his instructions in the matter. List again on,
After first week of January, December, Lordship.
list again on 9 December.
Lordship.
No, 10th of December.
Hearing day. Bless.
My lord, yesterday, my lord, the petitioner was called, my lord, by the joint director, and a few documents were taken, his test reports were taken, we have submitted yesterday.
You have?
We have submitted with him, my lord, yesterday. He called us, that you come to the office and submit your test reports. And we have submitted all the test reports. My lord, what happened? For this interview, my lord, department conducted one test, my lord. That was the first test. I'll give the dates, my lord. Thereafter, I was not selected. Then I went to private agency and I conducted 2 tests. There it was above 50%. Then again, there were many complaints from many candidates, and then government conducted another test, my lord. After that test also, my lord, what I did, my lord, I went and I conducted the test directly at GMCH, BERA test. There it was 57.1%, my lord. So that is my case, my lord, that after the test conducted by the department at the GMCH, I myself conducted the test at GMCH where it is 57.1%. Then how come few days earlier when they conduct the test, how come it's 23%? And I am a person with benchmark disability. There is no question about it. I have all the documents, and my case, my lord, is different from all the other cases they have mentioned about the series, my lord. Series is different, my lord. They are relying only on the ID card. Their pleadings, I have checked, their pleadings is that since an ID card is issued, as such, no further test should be there. That is not my case. My case is that if department wants to conduct a test, they may conduct it, but the test conducted by them is wrong. Now, my lord, a BERA test, my lord, takes 40 minutes, my lord. And very surprisingly, what has come out, my lord, in one day, my lord, with one BERA machine at GMCS, the department has conducted 120 tests.
Is it possible?
Not possible, my lord. One BERA test takes 40 minutes, and they have conducted for BERA test for 120 candidates in the same day with one machine at GMCS, my lord, and all wrong data they have provided, my lord. My lord, these are the candidates, my lord, with benchmark disabilities, my lord.
They have few quotas, my lord, where they can get the jobs, my lord. And my lord, if tests are done in this manner, my lord, it is very illegal, my lord. And my lord, my case is, my lord, is open and shut case, my lord. Government conducts the test on.
Right, first, let us understand what the department will have to say, Mr.
My lord, yesterday I submitted the documents.
Upamanyu, we had requested.
I got the, my lord.
You are for health.
No, my lord, yes, my lord, we have got the report from the joint
This is
director.
happening, this is coming up time and again.
Yes, sir. In, my lord, in every selection now probably this is done. But so far as the, my lord.
There is no quarrel that you cannot do it.
Fine.
Or you may have your own rules to do it.
Fine.
What we want to know is, what is the basis of reliance on your examination and discarding?
That's why, my lord, Lordship will see, my lord, the instruction that has come up.
Ah.
So far as, my lord, this ID card and all which has been issued to the petitioner recently, my lord, which is at page 43 of the writ petition. That was issued, my lord, without any examination. That is what the instruction says. They simply relied upon this certificate which was issued in 2014 at page 44.
Which was issued?
Page 44, Lordship, may kindly see.
44.
Yes. The petitioner got this disability certificate sometimes in, my lord, December 2014. Page 44.
Yes.
Now, my lord, my lord, the petitioner appeared before the authority sometimes in February 2021. There, my lord, the digitalized certificate and all were issued. Without any examination, only, my lord, converting this particular certificate of 2014 in the digitalized manner, my lord. That is what the instruction says. Lordship may kindly have a look at the short instruction, my lord. Here I would like to file the affidavit because this has come up that without examination for the second time when it was issued, only, my lord, it was digitalized, my lord. Instead of, my lord, going for a fresh examination in 2021. That ID was issued to the petitioner.
Bring it on record.
My lord, the first page of the instruction, my lord. Second page says, my lord, further on so and so applied for digitalized PWD application based on the office record and manual certificate, UDIN card and disability certificate approved.
No. You've got an UDID card and disability certificate.
Yes, based on the 2014 certificate, not after due examination again in 2021 or so.
No, this certificate is applied for digitization of PWD application.
Yes.
What is the meaning of that?
Well, now it is online, madam. In a particular format, it is given.
What?
Earlier, it is handwritten.
Certificates.
Yes, page 44, Lordship will see, and page 43 will be evident.
So these were the earlier certificates.
44 is the earlier one of 2014. 43 is the one which has been issued in 2021, February. Just more than, my lord.
So you want to say that 43 was issued based on 44?
Yes.
And 44 was issued?
That record they don't have, my lord. That whether examined, not examined, whatever was there is not there as on date. My lord, within 1 day they could not furnish everything.
All right.
So I will file the affidavit, my lord, bringing this into record.
We will have to.
My lord, may I make a submission, my lord? My lord, advertisement was published on 25/3/2022. Subsequent to that advertisement, I have applied. My lord, the results were declared on 3/5/2023. I was not selected, my lord. Then, my lord, I went for private test on 25/5/2023. Then again, I went for a private test on 24/6/2023. Then there were complaints from many candidates and government went for a retest on 3/8/2000. No, government went for a retest on. No, আমি হে কৰিছো.
No, let him bring it on record. Let him file the affidavit.
My lord,
first.
My lord, I have the certificate from the GMC.
We want to find out that what the department has to say with regard to your unique disability IDs and other documents issued. Otherwise, there is no meaning of issuing a unique ID. The unique ID is issued by a government authority.
Lordship, this case, my lord, have already, they are on the verge of making the appointments, my lord. My lord, may kindly come to page
Meanwhile-
64.
meanwhile, you have now submitted your documents to the medical authorities.
No, joint director.
No,
Yes.
You are submitting yourself for a further examination.
Not submitting, my lord. They have filed an affidavit before this court
Hmm.
that I may be required for re-examination. Then my submission was that, my lord, I have all the certificates, all the test reports. Now, whether I have to go for a test, retest or not, that lordship will decide. My only prayer was, if lordship is sending me for a retest, then this writ petition may be kept pending and I may be sent for retest. Otherwise also, my lord, after their test, my lord, I have conducted the test at the same place with the same machine which they have used to test me, that is at page 64.
When is the retest scheduled?
Not scheduled.
Not scheduled.
They are asking only for this
No, no, in the
petitioner special.
affidavit, we have stated that if required, he can go for further, my lord, verification.
Have you called them?
No, my since it is pending for this honorable court, if honorable court directs, my lord, then of course we can.
We are not directing unless you want it.
No, my lord,
Yes,
that
for sure.
examination pursuant to the selection, it was already conducted. He was found to be 23%.
Ah.
Now he's challenging that, my lord, on the ground that subsequently he went to GMCS and this time he has been found to be 57%. That is his, my lord, ground for challenging it to prove that, my lord, we were
Then
wrong
you
in the.
conduct- Then you conduct a retest.
Sir, my lord,
My
let
lord.
me file the affidavit first, my lord, at least thereafter.
My lord, this thing is not yet coming up for consideration before the court. There is one order of your lordship also, order dated this one. Lordship, kindly peruse order dated 4/8/2025. 4/8/2025, my lord. That was your lordship's order only. 4/8/25.
All orders are our orders only.
Yes.
What difference does it make?
Yes, my lord.
All orders are orders.
Yes,
of the
fine.
court.
Yes, my lord.
Ah.
No,
It
kindly see, my lord.
got adjourned.
No, my lord. 4/8/2025.
When, huh?
4/8/2025.
4/8.
4/8, my lord. Mr. So-and-so learned standing counsel health will produce the relevant medical records of the petitioner undertaken by the medical board constituted to examine the percentage of disability of the writ petitioner. The medical record must reveal as to how the test was conducted and percentage of disability shown by the medical board to be at 23% in respect of the writ petitioner was arrived at. These records have been called for in view of the fact that no affidavit by the health department has been filed in view of the submissions made by the learned counsel for the petitioner that on a medical examination before the ENT department of the Guwahati Medical College subsequently undertaken by the writ petitioner, the percentage of disability in so far as the petitioner is concerned was arrived at 57.1% and which, if correct, will make the petitioner eligible for being considered for the post of which he has applied under the category of hearing disability as he satisfies the benchmark disability of 40%. That report, lordship, is page 64. একখন চাব লাগিব এইটো আছে 80 ফৰ্মুলাটো এপ্লাই একখন চাব লাগিব দেখাই দিছো they have not replied, my lord. They have not got anything against with regard to the query of the court in that regard.
That also will file one affidavit, but here, my lord, that
Whether this report is fake, my lord.
percentage perhaps
They
will
are
not
saying
be
that my
mentioned.
certificate, my ID card is without any consideration, without
You
any.
file an affidavit in
Yes.
terms of the earlier order. Give
Yes.
us materials.
Yes, my lord.
Support it and
No,
show us.
but my lord, see, so far as this document at page 64 is concerned, that my learned friend is relying upon, that 57% has not been mentioned by the medical authorities.
We have to refer the act, my lord.
Then it is his own calculation.
No, not my own. Now,
No,
lord,
that I'm saying, my lord.
his submission may be recorded that this is not 57%. He may apprise this court on affidavit that what percentage it is. I will refer the act. The table is there in the act. As per the act, it is 57.1. I can show the calculation also.
And this was up to
And they have not denied these averments made by me in their affidavit, my lord. If not denied, means accepted. Now, if they want to deny, then they may say that the test reports from page 64 to 69, whatever test was conducted, whether it was actually conducted at GMCS or not on 16/11/2023, one, and secondly, if it was conducted, what percentage
Yes,
was
that
found?
will place them. That will place.
Because these are not fake documents. We have conducted.
Where are the readings here?
My lord, kindly come, my lord, page 68.
Huh.
Now, my lord, kindly see, my lord, the peak, my lord. Peak was at 80, right 80 and left 80. Now, my lord, what is told to me? 80 we have to subtract by 10. Then it will come 70. Then we have to refer to the act, my lord. The table is there, my lord.
No, where is the peak here? We can't.
My lord, middle one, my lord. V written, my lord. That is the peak, my lord. Then
He written above that also, 90.
yes, my lord, but this is taken, my lord. 80 is taken as per our instruction, my lord. 80 is taken, 80
So
decibel.
let an affidavit be filed.
Yes,
Yes.
my lord, specific order may kindly be passed, my lord, directing them to reply to this report that what is the percentage as per this report.
That we will place.
We'll reiterate the order already passed on 14.
Pilot. Pursuant to earlier order, will file the affidavit.
Heard Mr. F. Khan, the example petitioner, Mr. D. E. Gugoi, learned additional AG appearing for the state, and Mr. D. Upamanu for the health department, Mr. CKS Borua for.
Personality department.
Huh?
I am appearing for all my.
So he's the additional. And Mr.
State level recruitment.
Yes, Mr. Chaudhary for state level recruitment commission. Stop. Pursuant to the earlier order dated 12/11/2025. Mr. Gugoi submits that he received his instructions and he'd like to bring on record by way of filing an affidavit. So Mr. Khan on the other end has referred to the order dated 4/8/2025 passed by the court, whereby a direction was already issued to the health department calling for medical records to show as to how the test in respect of the writ petitioner was conducted and the percentage of disability shown by the medical board to be at 23% was arrived at. These records had been called for as no affidavit by the health department was filed. These records were also necessary as it is the contention of the counsel for the petitioner that on subsequent medical examination by the ENT department of the Guwahati Medical College, which was undertaken by the writ petitioner, the percentage of disability insofar as the writ petitioner is concerned was arrived at 57.1%, which, if correct, will make the petitioner eligible for being considered for the post in which he applied under the category of hearing disability. Better. Mr. Gugoi, however, submits that he has received his instructions and therefore he may be permitted to bring the affidavit on record on behalf of the health department. So in view of the submissions made before this court by the additional AG, we grant further 3 weeks. 3 weeks time.
Second week of December.
To permitting the state to bring on record and to apprise the, bring on record the relevant materials and to apprise the court the different they bring on record the different test readings which are reflected on the tests undergone by the petitioner showing his disability. Let this matter be listed again after 3 weeks.
My lord, there was, my lord, subsequent advertisement by them, my lord, and I have filed an IA with regard to that advertisement, my lord. The post for which he is competing, my lord, that post is covered in that advertisement, my lord, and results has been declared on 9th of October 2025. And my lord, they are very likely to make the appointments also. And if they make the appointments, my lord, then my lord, this writ petition will become infructuous, my lord.
Any appointments made will be subject to the outcome of the writ
That
petition.
observe, that is order is
My lord,
not
that
there.
is not under challenge here. Because there's a fresh selection. He is, my lord, confined to his selection that was held
But
in
that, those
2022.
posts are there, my lord. That's why, my lord, one post may kindly be kept vacant, my lord.
That lordship will take care of, my lord, if it is
Any-
found that he is
any- If
eligible.
it is found that the petitioner has been wrongly rejected on the ground of medical, has been rejected on wrong medical, on tests undertaken by the department which were incorrect, Kumar, then
And also, my lord, if otherwise, my lord, on merit, he was eligible.
further, then necessary orders will be passed by the court directing the respondents to give appointment to the petitioner. So if it appears to the court that posts are not available, then the respondents will have to make available posts to accommodate the petitioner in the event that the petition.
I'm grateful, my lord. I'm so grateful, my lord.
Yes,
Lordship, I have,
complied, not complied.
Lordship, here we are in the process of complying, Lordship. Lordship may just.
Process of complying.
Lordship, we have received a proposal of 1,200 muster roll workers, Lordship, in which the petitioner is also included, Lordship.
Okay.
There was a cabinet meeting, Lordship. Now a committee needs to be formed to verify all the documents, Lordship. So some time will be required, Lordship. I have placed the record. There was a cabinet meeting. I can provide a copy of the instruction to
It's moving, but little slow.
Lordship, because there are more than 1,200, not just the petitioner, Lordship. I've provided a copy of the instruction.
N.S. Thakuria appears for the petitioner. Mr. Echolia for the finance department, Mr. Hazarika for
Respondent number 1, 2, 3, and 4.
I'll be appearing for respondent number 5.
Mr. Cholia for 5, Mr. Hazarika for 1, 2, 3, 4. Mr. Cholia submits on instructions that the proposal for granting of minimum scale of pay to muster roll workers have been received by the finance department, comprising of a list of about
31 muster roll.
1231 muster roll workers, which includes the present petitioner or petitioners.
Petitioner.
Petitioner.
Petitioner. So he, however, submits that this verification process will require some time. He prays for further 4 weeks.
4 weeks, yes. Somewhere in December.
4 weeks' time.
4 weeks,
We comply with the directions contained in the order. Let this matter be listed again on 14 December.
14 December will be
17.
Sunday, my lord. 15,
Sorry.
15, my lord.
15 December.
15 December. 15 December. Or let us have it on, yes, 15 December. 15 December. Let's take what. Yes.
Lord, in these two cases, my lord, the first one in item 51. Oh, item 51, my lord, copies have been served on last Tuesday. My lord, we'll.
Both are same.
Both are same, but then we'll. We'll file identical affidavit in opposition, both the cases. My lord, my lordship will grant us some time, but my lord.
For interim order.
That's right, my lord. I find that there is an order passed by your lordship. There was an order passed by your lordship. I find, my
We are
lord,
not getting our pension since long, but
that the interim notice on the interim prayer was issued. Now, my lord, the petitioners basically, my lord, are claiming the interim relief on the basis of an order passed by the Madurai bench of the Madras High Court, Honorable Madras High Court, making this where the same challenge was made before the Madurai bench of the Honorable High Court. But my lord, it happened like that. The Madras High Court has passed another order.
Contrary.
Yes, my lord, dismissing the writ petition and upholding the challenge, the order passed. The lordship will kindly have a look. Upholding the impugned order, my lord, passed by us, that the,
Division bench.
no, my lord, it is the coordinate bench. This order was not placed before the Madurai bench. That's why, my lord, the offender. Therefore, my lord,
This was an earlier order.
the earlier, this was not placed before the, lordship will kindly see the first part and the interview. The same challenge, same prayer. It was by another organization. So this was not placed before the, therefore, my lord, we'll file our affidavit in opposition, making our position clear, because it will have an impact throughout the country. And therefore, my lord, lordship will.
What is there, where is that impugned order, 18-1?
18-1 order, my lord, is in the first case.
Page 270.
Yes.
What is the effect of this?
My lord, they'll get lesser, I mean, the pension, it is based on, my lord, my lord, option, by joint option by employer and employee. So this option was accepted, because although, my lord, the trust rule did not provide for such option. That is why, that is the, my lord, the issue that was raised before the Madras High Court, and the Madras High Court has said unless and until the trust rule is amended, this cannot be accepted.
What rule?
Trust, they are governed by their own trust. They are exempted establishment. So their trust, they have their own rule. This trust rule doesn't provide the provision for joint option, and the employer is not liable to make any contribution on the higher subscription that they make. That is how, my lord, and the Supreme Court also did not deal with this aspect of the matter in the case of, my lord, the Sunil Kumar. And therefore, the Honorable High Court has held, my lord, that trust rule has to be first. Then I will file, my lord, within a fortnight's time, my lord. Then your lordship will hear the whole matter, my lord.
So far this case is concerned, your lordship just come to page 270.
270.
270.
Yes.
Now, second column, second row. The eligibility for pension on higher wage cases should be determined on the basis of the extent trust rules of the exempted establishment in consonance with the direction of the Honorable Supreme Court Sunil Kumar case. Further, that is not correct. Further, in case of the trust rules are amended, post decision dated 4/11/2022 in Sunil Kumar case, application of the members of such trust may not be considered. So what is happening? There are some establishments where the provisions of Provident Fund Act is not applicable. If the trust, they are governed by the trust, and if the trust provides better amenities, then that will not be applicable. So, but so far the pension is concerned.
Where are your trust rules?
Yes, that is the trust rules you also will find at page 50. Now, this is trust rule.
50.
50. Indian Well Corporation Limited Refinery Division Employees Provident Fund rules. Now, so far this point is concerned,
This is what? This is a trust.
Trust.
What is the trust called?
So far the Provident Fund Act is concerned, both employer and employee are liable to pay contribution. Now, if any establishment provides better benefits, then they are exempted. They are exempted, they will be regulated by their own trust rules. So far this case is concerned, they have their own rules, that is called as trust rules. But so far this aspect is concerned, your lordship straightway come to the page 89.
Yes. Yes.
Page 89, relevant page. Which is statutory provisions to have the overriding effect.
Where?
Rule 47.
47.
In the absence of any specific provision in the rules, if any provision of the rule is less beneficial, then the corresponding provisions of the Employees Provident Fund and Miscellaneous Provisions Act 1952 and the Employees Provident Fund Scheme 1952 framed thereunder, thereunder provision shall prevail.
So what is the benefit given under these rules?
Yes, that is the main point. And that point was has been dealt by the Madras High Court also, Millard. First. Now you should be come to benefits of pension scheme. Pension rules, Provident Fund rules, paragraph 27, AA.
Provident Fund rules, is it a part of your pleadings?
Huh?
Is it here?
Yes, the book. There is book. Paragraph 27, na?
Provident Fund.
Employees Provident Fund scheme. Page 84 probably in these books. Frequently intellectual act level. Use mass case. No, you also will find in this petition also, if come to page 163. It is quoted. Page 163. Relevant page 165.
Abdul. Abdul Hamid পড়ছেন তো?
দেখলাম মজুরি কেস সবাই বলে 27 AA. Provident Fund scheme. Age, extension of time, age. June 19. Yes, yes. No, the should come to please. Page 292, paragraph 27 AA. It is quoted here. The balcony can top of it. Here in 292. 292, paragraph 32. Paragraph 27AA of the Provident Fund Scheme. Provident Fund schemes deal with the terms and condition for granting exemption of an establishment. Condition number 10, Appendix A, extracted as follows. Any amendment to the scheme which is more beneficial to the employees than the existing rules of the establishment shall be made applicable to them automatically pending formal amendment of the rules of the trust.
Okay. Now, in terms of this impugned decision, page 270, where is the decision taken to give you lesser amount of benefit?
Yes.
They have automatically.
They have page number available. Yes, that is the class of the page number available. Right. 233, no?
200 higher pension, 233 the lesser.
Yeah. First, your lordship come to page 200. That is
200.
higher pension.
200, yes. Yes.
This is higher pension.
202.
202.
How long are you going to take to file your affidavit?
My lord, lordship will give me 10 days time, I file, lordship will hear
So
today.
we'll take up the matter.
Lordship,
in
that's
an
better.
entirety.
That's better, my lord, I'll.
No, we are not getting pension. That is the
No,
problem.
no, they're getting, but in lesser.
No, we are getting 30,000. Now we are getting 2,000 or 3,000.
No.
We have contributed more than 20 lakhs. By taking bank.
No, no,
Why
that
not
will go.
30 only 2,000?
No, it's under the scale, no 2,000, my lord. It shouldn't be.
Yes, 2,000,
But, my
3,000.
lord,
I have
they-
given the package.
Pension, because it is pro rata on the basis of pension, my lord, deposits made. That's how the amount is less. No, Lord, I'll file my affidavit, my lordship will hear. Even on the interim prayer, lordship may hear on the next date. I have no objection.
No,
I'll
your
file my
objection
objection
is
on
not
that.
viable. It is a entire thing is
Now,
before your
page-
lordship.
All right, page number 200, you are showing monthly pension of 30,112.
Yes.
Is that the pension?
No, that was what we were getting after we paid that money. Now it has come down, my lord. That
Why,
your
why,
lordship
why
will
has
find-
it come down? Why has it come down?
No,
That is the whole
because
crux of this case.
No, what, that is what we want to know. Why has it come down?
Now, actually, background
Where is the
is.
policy decision?
my lord, it happened. All right.
Let's. Under the pension scheme, there is a ceiling limit. There was a ceiling limit.
Right.
So whatever be your salary, you will not get the pension on the entire salary. That ceiling limit was lifted in the year 1996. Now it is again imposed in the year 2014. 11 footer. Again imposed 2014, and the pension authority gave an option to the employer and employee to contribute their pension, their dues to the pension fund. If they can contribute it, then they will get the pension on the actual ways.
Get the pension on the?
Actual ways. Actual ways. Now, their provident fund was deducted on the basis of the salary drawn to the extent of rupees 15,000. But each employees are getting salary more than 1 lakh, 150, something like that. But provident fund authorities deducted the provident fund contribution to the extent of rupees 15,000. So remaining amount of contribution had to be paid by them, by the employees. So they preferred an option, all that we shall pay it. So each employee had to pay with more than 20 to 30 lakhs with interest. After due payment, the pension on higher wages was initiated, was given for a period of 5 or 6 months. all on a sudden throughout India, all on a sudden, they have stopped and they come back, reverted back to the earlier pension. And they offered us
Earlier pension of the ceiling of 15,000.
ceiling of 15,000. And they prepared.
Is it pursuant to a decision taken by the
Supreme Court.
No.
Supreme Court, Sunil Kumar, my lord, that is why, my lord, that's why
yes,
interpretation
correct,
of
but-
the Supreme Court will be decided, the lords will have to interpret the Supreme Court decision, then.
Yes, I will.
I'll, my lord, that's why.
Now, Supreme Court decision is also before your lordship. I mean,
Page number?
page number is 111.
Correction is at page 156. Operative part, page 156, paragraph 14. One 56, page, paragraph 44 is the direction.
Starts from page 112, no?
Section to that.
That should have changed.
56.
163,
56.
56.
Yeah, 156 to that.
Yes.
It is the 163.
No,
Now, Abdul Hamid देखो तो.
it's over.
156.
Who given
Paragraph 2 and 3, no?
the page, paragraph 44.
Paragraph 44, subparagraph 2 and 3. Okay, let me read. Subparagraph, we accordingly hold and direct the provisions contained in notification number such and such legal and valid. So far the present members of the fund are concerned.
No, this
we,
will require some examination.
yeah, just straight away, subclause 2. Amendment to the pension scheme brought about by the notification dated 22nd August 2014 shall apply to the employees of the exempted establishment. We are the employees of the exempted establishment. Bongaigaon
So where
Refinery.
is this notification 22nd of
Yes.
August?
Yes.
The government pursuant to this order, we were.
No, no,
I give you a lordship, my lord, typed copy.
Is it not here in
That is very, not very legible, I found that, so.
No, that's true.
page number?
This notification was upheld by the Supreme Court.
104.
This notification was upheld by the Supreme Court, but Supreme Court gave me a 4-month time to make option.
Phase option.
Exercise option. Accordingly, options were exercised and pensions were given on higher wages, all on a sudden for the reason known to them best. So they have stopped it. This is the facts of the case. Even the Calcutta High Court,
So after the judgment of the apex court upholding the notification, they have continued to give you pension at a higher amount or whatever amount you think.
Supreme Court upheld this notification.
That's right.
And then Supreme Court, in exercise of their power under Article 142, extended the time
Exercise the option.
to exercise the option.
That your lordship will find at page 158.
158.
No, so therefore, this amount suddenly coming down
No.
Oh,
for going back to the earlier
yes.
scheme, why and pursuant to what orders?
According to this order, just page, according to their own understanding, that is the impugn order as page
Separate order was passed.
270. Page 270. That is the simple case. They are under impression that if there is a trust rule and trust rule does not permit it, then you are not entitled to have.
Which,
There is a-
which according to you is contrary to the directions of the Supreme Court.
Yes.
Supreme Court.
Supreme Court and Madurai High Court, even the act itself, paragraph 27 AA.
Supreme Court says that this notification is to be, will apply equally to the
exempted
employees of the exempted.
Accepted establishment provided they
Yes.
covered under 26 and 6. My lord will kindly see para 37, page 150. Supreme Court, what Supreme Court has
Yeah.
said about it.
No, but
150.
this
Very
directions
simple
are in
case.
page
No,
40, para 40.
the Supreme Court has held that we, my lord will page 151, lordship will go. 151. Lordship, 151. Lordship got it.
Yes.
We would, second line, we would point out here, before us, no argument has been advanced as regard the members of the pension exempted established in terms of so and so. Thus, in this judgment, we are not addressing the cases of category of members. So, my lord, lordship will have to examine
No,
the whole
case is
matter, my
just
lord, I'll place by.
Then how do you give, what meaning?
No, my lord, that's why it means, as per the exempted establishment, there is a specific bar. Therefore, the Madras High Court has held, lordship will so and so. Well, now in para, the copy I've given, when the trust rules have explicitly barred increase of the employer's
It is
contribution.
their own understanding of law.
No, this is the court's understanding. Court's understanding.
Supreme Court had directed for a 160.
Lordship will
You
give me a
find
time.
we'll take up this matter.
It is
Lordship,
directed. আর এখানে ওরা বলেছে
Mr. Dasgupta, I think this is essentially your final prayer to give you
Yes.
rates at the.
That is up to your lordship, Lord. But if the, so far their own reaction, your lordship will page 164. Page 164, কত নম্বর প্যারাগ্রাফটা?
এই তো এই যে এখানে দেখুন therefore in compliance of the Supreme Court order.
Page 164. From Provident Fund Authority's own order. Paragraph 5. Therefore, in compliance of the Supreme Court judgment dated 4/11/2022, following employees with their employers may submit joint option. They may offer under paras 11.3 and 11.4 to the concerned regional office. And accordingly, we were called upon to submit our option.
We applied, we submitted our joint option.
We submitted our
They
joint option.
calculated our area amount to be deposited. They made calculation to deposit the area amount. That area amount was also deposited and then they started paying the higher pension. Pursuant to the Supreme Court's order, my lord, they directed us to apply that within that time.
Yes.
We applied, then they made a calculation because initially we were contributing at the ceiling of 15,000.
Yes.
Now, because of the Supreme Court's direction, now we have to contribute at our higher way. So they made a calculation and each of the employees were directed to deposit this much of amount. We have given it that amount. How much amount they were directed to be deposited. We deposited the money and on the deposition of such money, they
Who directed you to deposit?
Yes, Employees Provident Fund.
They directed us.
They first invited us to exercise the option in terms of the Supreme Court judgment. Then we exercised our option, then they made a calculation that this employee, your deposit, you have to make an arrear payment of this much to be a part of this scheme.
Yes.
We deposited that amount. And after that amount was deposited, they started paying our pension at the higher way. They continued to pay it up to June 2025 and from July 2025, they stopped it and while stopping it, no notice was issued. This is what we apprehend that this is the reason for which they have reduced it. But in fact, after continuing to pay pension at a higher amount, they abruptly stopped it without issuing any notice as to why it has been cut down. That is why there is a prayer for interim relief so that we continue to get our pension because they are not making the pension, granting pension on our own. We have contributed for that. We have paid 20-30 lakhs rupees as arrear contribution with interest. Not only that, my lord. And for higher contribution, income tax deduction was also made.
Yes, all these things. And similarly, Calcutta High Court also passed.
So
order.
now the
Same order.
Where is it? I got.
Page 301. Same thing happened. The Calcutta, page
That
3.
was based on Madurai bench.
Not Madurai bench. It is the independent order. 301.
Lordship will see.
Mary Miller, the present application has been prefer praying for direction upon the respondent not to give effect of the letter dated 19 March 2025 and for further direction upon the said respondent to process and approve the option forms for higher pension in strict compliance with the statutory provisions of the Section 17 and 27A of the Employees Provident Fund and Miscellaneous Provisions Act 1952 and the Employees Provident Fund Scheme 1952.
Here are orders, but Mr. Das Gupta, Leonard Senior Counsel, assisted by Mr. Chakraborty and Mr. Counsel appearing for the Provident Fund.
Yes, sir. As per number 2 and 3.
2 and 3 assisted by Leonard Counsel, so and so. The Counsel for the Provident Fund has entered appearances and has prayed for how much time?
Lord, let it be fortnight's time, my lord.
2 weeks' time. Complete his instructions and file necessary affidavit. The counsel for the petitioner has renewed his prayer for interim orders.
84.
178 of that one.
For the petitioner submits that the directions of the apex court considering command be recorded in 2023-12 SCC 701 has been misinterpreted by the respondents. And accordingly, the amount of pension payable to the petitioners have been suddenly reduced, giving them at present only paltry sum towards pension. The learned counsel, senior counsel submits that pursuant to the directions of this apex court, the applications were invited from the petitioners for application was invited for
higher pension, for contribution.
Exercising option for higher pension on actual
exercising
way.
the option for higher pension.
It is not from the petitioner for a general notification was issued for all.
All right.
It is
Well,
in
no.
respect
For
of
all,
those are.
For all, throughout India.
In which the petitioners represented, responded to, and have also made payments of the area amount.
Yes.
My lord may have a look at page 178. That is the demand notice where they have made calculation area pension with interest. 178 is one of such letter.
One of the
And
24,41,000.
on making the necessary calculations, a demand notice was issued by the Provident Fund, copy of which is available at Annexure I series page 178, whereby the amount
Different amount.
due to be deposited by persons by the petitioners was issued. And the said amount was duly deposited by the petitioners. Thereafter, the petitioners were granted their pension, applicable pension at the applicable rates. So suddenly, pursuant to a purported policy decision or a clarification taken by the Employees Provident Fund Organization issued on 18/1/2025, the earlier proposal for grant of pension at a higher rate was altered, and without putting the writ petitioners to notice or issuance of any fresh orders, expressing the decision of the Provident Fund Organization to issue pension at reduced rate. So, under such circumstances, the writ petition has been filed. Counsel for the petitioner has referred to the judgment of the Madras High Court Madurai bench, as well as a judgment, as well as an order passed by a coordinate bench in the Calcutta High Court, whereby interim orders have been drafted. Stop. The counsel, senior counsel for the respondent on the other end is referred to and relied on the judgment of another judgment of the Madras High Court. And wherein such petitions filed by the petitioners before the Madras High Court came to be dismissed, and the action of the Employees Provident Fund organization was upheld. It is submitted by the Learned Counsel to the respondent that the judgment of the Madras High Court dated 3/7/2025 passed in WPC 1522 of 25 and WMP number 17174 of 2025, although was passed at an earlier point in time, was not placed before the Madurai bench of the Madras High Court at the time when the judgment dated 2/9/2025 was passed by the Madurai bench of the Madras High Court in WPC number so and so, page number 272. He therefore submits that there is no infirmity in the action taken by the Employees Provident Fund. Well, having considered the submissions made by the council and also upon perusal of the judgments pressed into service, this court is of the view that prima facie, this court considers that the interpretation given by the apex court in Sunil Kumar is required to be followed by the parties concerned. And in view of the public notice issued by the Provident Fund organization and followed by a demand notice, a public notice issued by the Provident Fund, pursuant to which the options have been offered by the writ petitioner, and the subsequent demand notice issued by the Provident Fund organization calling upon the petitioners to pay for the arrear amount reflected in this demand notice, which have also been paid by the petitioners. The petitioners having been granted a pension at a higher rate till the same was discontinued by the Provident Fund Authority without prior notice or any specific orders. This court is of the view that an interim order is called for in favor of the writ petitioners. It is therefore directed that the pension at the high rate which was being granted to the petitioners prior to the same being discontinued by the respondents will continue to be paid till further orders passed in the writ petition. Further orders passed by the court. Let the matter be therefore listed for hearing on completion of the proceedings. List again after 2 weeks.
Next one. It is Bongaigaon refinery and next one is for Guwahati.
Item 51 is.
May not, let it be in place of 2 weeks, let it be 3 weeks, because I have to get it from, they are having interim order in their favor, no problem.
So this is IOC.
51 is Bongaigaon refinery and 52 is
Guwahati refinery.
Guwahati refinery.
Organization is under
The same, but the
refinery is actually different.
List one of Sailuba Likas. Yes.
Resolution item 53.
The Lordship, I placed the last extension order.
That is 10 September.
With effect from 10 September. For under 3 months.
Yes. Where is the extension order?
The extension order.
Oh, in the IA. No, this is for compliance of the directions of the court,
Yes, 342. In 342.
where you were directed to take a call without placing reference to the
89.
89. You are also a petitioner there.
My lord. My lord.
Not petitioner.
Not petitioner, my lord. I am in the cover case. I am.
Because his writ petition was filed on
So
13.
what has this got to do with?
His writ petition was filed on 13/2/25. So as per para 9 and 10 of the judgment, any writ petition which has been filed prior to 3/4/2025 will have to be placed before as a one-time measure before the SLC or DLC. This matter was not listed after that, Your Worship.
Okay, heard counsel for parties. The petitioners are agreed by the rejection of their
DLC.
DLC, rejection of their case by the DLC YD, which order?
Page number 19, my lord. 31 to the
31/2024.
By the order dated 30/01/2024, whereby, where is the petitioner, serial number?
Page 20,
Page number 20.
serial number
Petitioner?
7.
The
AK, page 20, serial number 7, Executive Engineer PHE Silchar Division. In the table, it is serial number 2, AK Sakhil.
Whereby the petitioner, whose name appears at serial number 7 in respect of Executive Engineer PHE Silchar Division number 1, stood rejected due to non-availability of grade 3, grade 4 posts on compassionate quota. So, the counsel for the petitioner, being agreed, has approached this court. He has faced reliance on the judgment and order passed in WPC number
Batch of writ petition
342. In the batch of writ petitions where the lead case is WPC number 342 of 2025. Which came to be disposed of by the order dated 3/4/2025. The important bench of this court, by the said order, disposed of this bunch of writ petitions with the following direction. Where is the judgment? Give it to us. Paragraph 9 and 10. The learned counsel for the petitioner therefore submits that he be permitted to, that his case be also disposed of directing the respondents, by issuing similar directions to the respondents.
Your Lordship, on last occasion, I placed the OM dated 30/8/2025, wherein in terms of this judgment and order, we had actually issued an OM inviting applications in a particular format. And that last date was 15/9. Now it has been extended till 10th of January 2026 in IA number.
The learned counsel for the petitioner, as also the counsel for the respondent, has placed before the court copy of the order dated 16/10/2025, filed in, passed in IA Civil 3268 of 2025, whereby he prayer for 3 months extension to comply with the order dated 3/4/2025, passed in WPC 342 of 2025 and other bunch of cases be granted with effect from 3/10/2025. Stop. The coordinate bench allowed the IA and granted 3 months extension for compliance. 3 months extension with effect from 3/10/2025 for due compliance of the directions contained in the order dated 3/4/2025, passed in WPC 342 of 2025. Another bunch of writ petitions. Stop. The counsel for the petitioner therefore submits that since this writ petition was pending at the time when WPC 342/2025 and other writ petitions came to be disposed of by order dated 3/4/2025. Directions contained in the said order are equally applicable in respect of the present writ petition. Stop. Such submissions are not disputed by the counsel for the respondent. Accordingly, the respondents are also directed to consider and dispose of the claims of the writ petitioner in terms of the directions passed in WPC 342 of 2025 and other connected matters by the order dated 3/4/2025, which subsequently stood extended by order dated 16/10/2025, passed in IA number 3268 of 2025. Writ petition accordingly stands disposed of. Let the exercise be completed within the period of time granted to the respondent and extended period of time granted to the respondent by this court, by the order dated passed in IA number so and so. Disposed.
Let a certified copy of the order be submitted along with the
copy. The petitioner will furnish a certified copy of this order before the competent authorities. End of the list, item 29.
Lordship, the claim is undisputed. The only issue is that when the PWD department is going to submit a fresh proposal, it can be disposed of directing them to submit a fresh
You
proposal.
submit a fresh proposal.
My lord,
You submit it. When will you submit it?
my lord, I will take instructions as to whether it is submitted already or not.
No, it is submitted. He says it was submitted. When was it submitted?
22-23 in the financial year
22-23. You need to submit a fresh proposal.
My lord. So my lord is disposing it or my lord will keep it?
We'll
pending?
dispose it off.
My
Directing
lord,
you.
within a month, we will do it, my lord. I will give a time frame. We'll submit the proposal.
Yes, Mr. Moduna.
Yes, Lordship, it can be disposed of, and within a month, they are going to submit the proposal. But you may direct the finance department to place it in the next budget session of the assembly.
Heard Mr. F.Z. Mazumdar, learned counsel for the petitioner, Mr. R. Dhor, additional senior government advocate, appearing for respondents 1, 2, and 3, Mr. A. Chaliha, understanding counsel, finance department. The claim of the writ petitioner, the present writ petition is that he is entitled to area salary from the period 1/8/2017 to 3/0/11/2018 for rendering his service as a master role laborer in the PWD department. You are asking for area or minimum scale of pay?
He's getting the minimum.
He is getting the minimum.
Only the area for that period, Lordship.
Only for that, is correct.
1/8/17 to 30/11/18.
So he wants area salary in the minimum scale of pay.
Minimum pay.
Yes.
This claim is made by the petitioner in view of the judgment and order passed in dated so and so, passed in Upendas, quoted in so and so, whereby master role workers were held to be eligible for grant of minimum of pay scale. So it is a claim of the petitioner that for the period 1/8/2017 to 30/11/2018, as per the notification issued dated 3rd of October 2019 by the Finance Department, his claim has not been released, considered and released. Mr. A. Choliha on the Council for the Finance on the other end submits that the PWD department had earlier submitted a proposal which included the name of the petitioner, and the same was submitted in the year 23, financial year 2022-2023. Stop. Since the period had already expired, if a fresh proposal is put up by the administrative department, then the finance department will undertake the steps necessary for consideration and passing over appropriate orders thereon. Mr. R. Dhor, appearing for the PWD department, submits that the petition, the department can submit a fresh proposal.
After verification, Lordship.
After due verification. And within a period of 45 days from the date of receipt of a certified copy of this order, and thereupon the finance department will
45 days
appropriate orders for release of the arrear fee of the writ petitioner, subject to the claim being found to be correct. There are Mr. F. Z. Mazumdar, counsel for the petitioner, does not object to the prayer made. Accordingly, on taking into consideration the submissions made, the petition stands closed, directing the PWD department, more particularly the respondent number
Number
1 or 2.
it will be chief engineer, my lord.
But he will send it to the commissioner.
Yes, my lord.
Then so we'll direct respondent 1 to call for to ensure that a proposal containing the petitioner's name be submitted to the finance department upon due verifications being caused within as expeditiously as possible within the outer limit of 45 days from the date of receipt of a certified copy of the order to be furnished, to be placed before respondent 1 by the writ petitioner. Stop. Thereafter, the finance department, don't know, arrayed as a party.
There is.
Arrayed. Yes. Okay. Finance department being respondent number 4 will take all necessary steps to issue appropriate orders sanctioning the said proposal by placing it before the appropriate authority for budget proposals. Before the end of the financial year 24-25.
No, my lord, it will be 25, 26.
25. Yes?
Yes, my lord, 25.
Thereafter, the steps be taken for release of the amount to the petitioner as found due. Writ petition accordingly